Quorum call.
Madam Speaker,
Has everyone recorded their presence? If so, the clerk will take the call. There being 137 members present, the House is now in session. The clerk will read the journal from the previous day.
Annapolis, Maryland, March the 1st, 2021.
Recognizing the majority leader.
Thank you, Madam Speaker. Move so much be considered the reading of the journal from the previous day.
So ordered. Petitions, memorials, and other papers. For the Committee on Economic Matters, report number 17. The clerk will read the first bill.
House Bill 907, Unemployment Insurance Study on System Reforms. Favorable amendments. Amendment number 1.
Recognizing the subcommittee chair.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
As amended, House Bill 907 requires the Maryland Department of Labor, in consultation with the Department of Legislative Services, to study various aspects of the unemployment insurance system, provide monthly status reports to the Joint Committee on Unemployment Insurance Oversight, and submit an interim report on or before July 1st, 2021, and a final report on or before December 1st, 2021, to the Governor, Senate Finance Committee, House Economic Matters Committee. Amendment number 1 is technical. Amendment number 2 alters and expands the items included in the study. Move the amendments.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. Question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Recognizing the gentlelady from Howard County in the annex.
Thank you, Madam Speaker. When I read this bill and got to the part that it says the report is due July 1 of this year, I wondered if we might consider an amendment to push that off. Right now, that particular department is so overwhelmed trying to help all of the people who are not getting their unemployment checks and dealing with fraud. It just seems to me not to be the time to be, excuse me, it's a long walk from my seat, not to be burdening them with doing a lot of work. Certainly the information being solicited is relevant and important, but the timing of it, I think, might be better spent doing things for our constituents and pushing off the date due till sometime after we've gotten caught up. Thank you.
Recognizing the floor leader.
Thank you, Madam Speaker. The department is planning on using a consultant to do this study. We have a letter from them indicating that, so they're not going to use their internal resources to do this.
Is there any comments on the amendment? Hearing none, the question now is the adoption of the favorable report as amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 908, Unemployment Insurance, Employer Contributions Payment Plans. Favorable amendments. Amendment number 1.
Recognizing Subcommittee Chair.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
As amended, House Bill 908 expands the requirement that the Secretary of Labor offer payment plans to employers all of the time, not just when the state is in the highest tax table. The bill also alters and clarifies a provision of the Relief Act as at the request of the Department of Labor. Amendment number 1 is technical. Amendment number 2 specifies that an employer who employs fewer than 50 employees and pays contributions is eligible to defer certain payments during calendar year 2021 and may be eligible to defer certain payments during calendar year 2022, subject to the approval by the Secretary, and repeals the provision that authorizes the deferral of certain reports. Move the amendment.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. The question now is the adoption of favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 1138, Unemployment Insurance, Maryland Department of Labor, Accountability and Oversight. Favorable amendments. Amendment number 1.
Recognizing the Subcommittee Chair.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
As amended, House Bill 1138 establishes various reporting requirements for the Maryland Department of Labor, including weekly and monthly posts on the department's website and specified reports to the General Assembly during a disaster in the unemployment insurance system. Amendment number 1 is technical. Amendment number 2 and 3 alter the ongoing reporting requirements, change the on-off trigger for a disaster determination, and modify requirements related to staffing during a disaster. Move the amendments.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 1139, Unemployment Insurance, Weekly Benefit Amount, Income Disregard. Favorable amendments. Amendment number 1.
Recognizing the Subcommittee Chair.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
As amended, House Bill 1139 increases from $50 to $200 the amount of other income that is disregarded when determining a claimant's unemployment benefits during the state of emergency related to the COVID pandemic. Amendment number 1 reduces the dollar amount from $300 to $200. Move the amendment.
The question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 1143, Unemployment Insurance, Work-Share Expansion Act of 2021. Favorable amendments. Amendment number 1.
Recognizing Subcommittee Chair.
Thank you, Madam Speaker. As amended, move so much be considered the reading of the amendment.
So ordered.
As amended, House Bill 1143 makes various changes to the work-sharing unemployment insurance program. Specifically, the bill allows individuals rehired following a temporary closure due to COVID-19 to be eligible to participate in the program. The bill also expands the range of work hours that may be reduced, provides the flexibility on reductions within a unit expedites the time frame for the application processing, and requires the Department of Labor to undertake specified notice and marketing efforts using available funds. Amendment number 1 is technical. Amendment number 2 alters the scope and program requirements. Move the amendments.
The question before the House is the adoption of the amendments. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendments have been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Recognizing the minority whip.
Thank you, Madam Speaker. I make a motion to reconsider the vote by which House Bill 260 passed second reader. I wish to bring the bill back to second reader for purposes of an amendment.
The question before the House is to reconsider the second reading of House Bill 260. All in favor signify by saying aye. Opposed, no. The ayes have it. House Bill 260 is on second reading. Clerk will read the bill.
House Bill 260, Courts, Jury Service, Disqualification.
The gentlelady from Carroll in the annex.
Thank you, Madam Speaker, and thank you for this opportunity. I appreciate it very much. I have an amendment at the desk. Amendment number 263-020-1.
Amendment number 1.
Move so much to be the reading of the amendment.
So ordered.
This amendment is very simple. It would not allow a person who is considered to still be on the sexual offender list to serve on a jury. Under this bill, we are allowing sex offenders to serve on a jury even after their prison term and probation. Many of these folks remain on the sex offender registry for 15, 30, or sometimes for life. So I would like to press that amendment. Conceivably under this bill, without this amendment, we are saying in the state of Maryland, we are okay with a registered sex offender serving on a jury.
Floor leader.
Thank you, Madam Speaker. And thank you to the gentlelady from Carroll County, and thank you for sending me that amendment yesterday. I appreciate your concern and your activity on this important piece of legislation and the opportunity to speak on this bill. The importance of HB 260 is that we're a state that is saying when you are convicted of a crime and you do the time and you take responsibility and whatever that judge and jury stated, that you are back to being a full citizen. We're saying as a state that you are not a second-class citizen for life when you commit a crime in our state. And our state has already actually said this in the bills that we pass under voter eligibility in our law in Section 3-102B. I would ask the body to resist this amendment on 2 grounds. One, whether you're on a sex offender list or other public safety tools, that's not considered part of your punishment, your incarceration or fine, or your probationary period. It's a public safety tool that should not have the same constitutional ability to deny your full rights of citizenship. The second thing I would add to the body to resist this amendment as well is the fact that the ability to serve on a jury is not just in the criminal context. I think a part of the amendments that have been offered on second reader have not really brought to light that there are trials happening every day here in the great state of Maryland on civil and criminal issues. And so when you deny someone's ability to be part of a jury pool, you're denying their eligibility to decide on a car accident case or a medical malpractice case and a host of others. So I'd ask the body to resist this amendment.
Thank you, Madam Speaker. If I can respond.
The maker of the motion.
Thank you, Madam Speaker, and I appreciate the good delegate looking at the amendment and discussing it with me. I think one thing that we need to remember is there's a limited number of dismissals for civil and criminal cases. And from the attorneys that I have consulted, it's only 4 to 6 on civil and 10 for criminal. And again, if it's conceivable for someone on the sex offender registry to serve on a jury, I think that's a problem. And I think in the state of Maryland, I would imagine most people would not be happy with that. And again, as far as, them serving their time, that's fine. But in the state of Maryland, we have said that even though you serve your time, some people remain on the sex offender registry for 15, 30, sometimes for life. And I would press the amendment on those reasons as a mom and someone that cares about the rule of law in the state of Maryland. So I press the amendment.
Floor leader.
Thank you so much, Madam Speaker. Well, one, I appreciate the maker of the amendment's points, but I would also refer her to Section 8-420 of peremptory challenges in criminal cases and the amount of strikes that are actually available. They range depending on the crime. And I would also state in the jury pool process, you have strikes by the judge for good cause for various questions and various types of biases that myself, as a prosecutor and defense attorney, that I have gone through individually. And I would also stress to the body again, we have to distinguish between punishment and a public safety tool. And when you are convicted of a crime, we have all types of parameters for our judges on what the minimum sentence should be on that and what the maximum should be, and the amount of probation that can range from 3 to 5 years. I want to remind this body, I'll give you a brief example, Madam Speaker, very brief. If someone is sentenced, let's say, to 40 years in prison, and they get out in 20 years, in this bill, they wouldn't be eligible to, and they got the full 40 years in their criminal case. They wouldn't be eligible for jury service till the 40 years, not when they got out, but what they were sentenced to actually in that case. So I would urge this body to resist this amendment. This is about we are a state that says that if you do the crime and you finish the punishment that you were given, that you are a full citizen, and that we don't have second-class citizens in the great state of Maryland. That you not only will have your voting rights back, but you'll be a full part and participation in society and serve our juries and embrace you as a member of our society. So I encourage the body to resist this amendment, Madam Speaker.
Madam Speaker, may I respond?
Maker of the motion.
Thank you, Madam Speaker. And I do appreciate the sentiments spoken, but when you're talking about individuals that are on the sex offender registry, whether they did something small or something egregious, we're talking about a jury found them guilty of those offenses. And they rose to the level of a judge saying that they are going to be on the sex offender registry for 15, 30, or lifetime. I think that is significant enough for the citizens of our state to protect our children and to not allow them to serve on a jury. So I press the amendment.
Madam Speaker, may I respond?
Floor leader.
Thank you, Madam Speaker. I would say to the good delegate that I have seen personally in committee so many victims of various heinous crimes. And I would say whether you're talking to someone who is a victim of drunk driving or sexual assault or any host of things, their pain and what they've been through cannot be quantified. But are we a state in which rule of law is what we go by, or how we feel on particular crimes and issues? We cannot say for one crime it's this and for another it's that. We're a state that says when you commit the crime and you do the time and your probationary period is over, you can be back to serve as a full citizen. And I would say that this body, especially in the Great Committee of Judiciary, has much of time to consider all kinds of bills on whether maybe punishment needs to be further. Maybe there needs to be a longer stint of incarceration for certain crimes. But we cannot treat people differently for different qualified areas of pain. So I understand the good delegate's point. As I said, being on a sex offense registry is a public safety tool. We do not view it as incarceration, as a fine, or as your probationary period, which does take away some constitutional rights and privileges that you have as a full citizen. So when you do the time, you do the time, and when you're back in our society, you are back, unless this state wants to be a state of first and second class citizens. So I urge to resist this amendment. Thank you, Madam Speaker.
Thank you, Madam Speaker. If I could just have one final statement.
The maker of the motion.
We are a state that honors the rule of law. Our rule of law allows for a sex offender registry, and it's done for a reason, because of the nature of the crimes offended to our children. So if we are a state that honors law, why would we make an exception in this area? So I would press the amendment for that reason, for the children of the state of Maryland, that we do not allow this. If it's okay for a judge to put somebody on that registry for a year, 15 years, 30 years, or life, we should honor that and protect the children of the state of Maryland. So I press the amendment, and I thank you.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Oppose? Noes have
Roll
it.
call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment. Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Special order calendar number 40. Clerk will read the first bill.
House Bill 670, Police Reform and Accountability Act of 2021. Favorable report is amended and adopted.
Sorry.
Recognizing the gentleman from Frederick.
A few questions for the floor leader, possibly followed by an amendment. And I just want to take a minute to say I appreciate the speaker's patience with all this, and a great personal respect for you, and the opportunity to have a great, robust debate on this bill. Thank you. For the floor leader, page 6, lines 7 through 8, you have added a time restriction for search warrants. 8 a.m. to 7 p.m. My question is, does this apply to both regular warrants and also no-knock warrants? Sorry, the chair of the committee.
Recognizing the chair of the committee.
Time limit applies to all warrants. It doesn't just apply to no-knock warrants.
And the second question is, does this section also apply to non-residences, commercial businesses, or warehouses?
It would apply to property, to real property. So yes.
So the bill says residences, but you're saying it also applies to non-residences as well?
It says residences and it says property, I think, but I would say that the point of the amendment, I'll just double check. In the case of a no-knock warrant, it means a search warrant that authorizes the executing law enforcement officer to enter into a building, apartment, premises, or place to be searched without giving notice. A warrant would also generally be able to be used to be for both a residential and for a commercial property.
Okay, so just to fill the members in, so I'm specifically referring to page 6, lines 7 through 8, dealing with the 8 a.m. to 7 p.m. restriction, which says a residence, but that's fine. I know this is a huge bill. There's a lot of words in it. Madam Speaker, I have an amendment at the desk. The amendment number Give me 1 second here. Apologize. It is 823-4271.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Okay. This amendment simply strikes the 8 a.m. to 7 p.m. requirement, and I'll explain why. Currently, there is no time frame requirement for executing either a search warrant or a no search warrant or a no-knock search warrant. By implementing a time frame, it's almost as if we're suggesting that there's no criminal activity after the hours of 7 p.m. or furthermore, before the hours of 7 a.m. To illustrate my point with that, I printed out dozens of recent searches through our state. Salisbury, Maryland, drugs, illegal guns seized. Frederick, Maryland, guns, illegal drugs. Another one in Salisbury, 87 heroin capsules, stolen handguns. Baltimore City, massive federal distribution charge. Prince George's County, Centerville, Frederick, Boonesboro. The largest drug distribution case in the Mid-Atlantic region was in Cambridge, 2019. We could move on to human trafficking. Montgomery County, 2019. Leesburg, Virginia, a couple weeks ago, right next to my house. What do all these have in common? They were all done with search warrants. Different times of the day. So now we're suggesting that we're only going to conduct these operations between the convenient business hours of 8 a.m. to 7 p.m. Well, I tell you, if I was a drug dealer, a gun runner, or someone who participated in sex trafficking, as long as I didn't do anything in between those hours, I'd probably be good. Because I don't want to go to jail. I think it sets the wrong policy. Furthermore, to illustrate my point, I'm going to bring up a Netflix series called Dope. It's about Baltimore City. I like Netflix. The last 12 months being quarantined, we've seen a lot of it. But in there, the star of that show says that, in quote, they making laws every day that are in our favor, man. Drug dealer. So again, I ask the body to vote for this amendment. Well, you cannot put a time frame for search warrants. Move the amendment. Thank you, ma'am.
Recognizing the committee chair.
Madam Speaker, let me begin by saying in the bill, the time limitation is in fact only on residential property. It is not on both residential and commercial property. You can get a search warrant for both residential and commercial property. That's what I was saying before. So I apologize for that. What we're talking about here is a time limitation on when a police officer can serve a warrant, can execute a search warrant on a residential property. And the reason that the committee did this is because when you execute search warrants late at night on property, you raise the possibility that you're going to have somebody who not knowing who's on the other side of the door, could respond with gunfire. That's what we saw with Breonna Taylor in Louisville, Kentucky. Everybody started shooting because nobody knew what was going on. The police officers were not properly trained. The police officers didn't properly announce themselves at the residence. The police officers didn't do what they needed to do to make sure that people knew that they were there because they had a legal warrant. That's why we have this time frame set in there. It's not to give criminals an additional a leg up on the police. The police are going to be able to go out and continue to do those investigations And if these criminals are just so brilliant that they're going to move their entire criminal operation at 6:59 p.m. just to get it to a residential property from a commercial property, and the police are properly doing that investigation, they've probably got a good investigation to arrest them at 6:59 and 30 seconds when they're on their way to the residential property. So I think what the time frame does is it ensures that when these search warrants are done at residential properties, that they are done well, they are done right, the police officers announce their presence, and they're able to execute the lawfully begotten search warrant. And that's why I would ask the House to oppose this amendment.
Recognizing the minority whip.
Thank you, Madam Speaker. And with all due respect to my friend, the floor leader on this, it's ridiculous. A warrant to search a residence shall be executed between 8 a.m. and 7 p.m. That's insane. So at 8 o'clock, the drug dealer gets all the drugs out, puts them all over the dining room table, and knows there won't be a search warrant. This is bad public policy. You don't think crime happens between 8 p.m. and 7 a.m.? You don't think a safe time to enter a home might be 3 a.m.? This is just terrible public policy. I urge you to vote for this amendment to allow the police to do their work, to actually keep people safe by being able to go in and execute a warrant at 4 a.m. I don't know who came up with this idea, but this is a really bad one.
Madam Speaker.
Will you respond? We have someone in the annex. Okay. The gentleman from Talbot in the annex.
Thank you, Madam Speaker. Could the floor leader rise for a question or two?
Good
Is
evening.
this on the amendment?
It is. I'm sorry, of course.
Good evening.
So the committee had a debate on this time frame. I suppose my question is, when you have a criminal who knows what the rules are, well, the rules of the police are, why would we let them sleep easy at night? They know they're criminals. To what end does this policy benefit anyone? You're saying to me, I think what you're saying, in answer to the sponsor of the amendment, the question is that we're trying to protect the police. Well, no. The police know what they're doing. They know how to do it. They know how to protect themselves. What the amendment's trying to do is assert the ability of the police to conduct a comprehensive investigation, which includes a warrant. This amendment resolves the fundamental issue, which is we're not here to protect criminals. We're here to assert the rule of law and give law enforcement the tools to conduct their job. How do you see this differently?
Committee Chair.
Thank you, Madam Speaker. What the committee is trying to do, and what this legislation tries to do, is it tries to set a very clear line that says, we believe that there is, in fact, a greater public safety threat to the police officers and to people who, there are times, and there have been many times, when people have been the victims of enormous brutality. In the case, again, of Breonna Taylor in Louisville, where you have people who die because police officers, poorly trained, arriving in the middle of the night, aren't doing what they need to do. This is a safeguard. It's meant to be a safeguard to say, look, we know that it is important to execute search warrants as part of criminal investigations. We know that it's one tool as part of a larger effort to go forward with those criminal investigations. We also know that people have Fourth Amendment rights. We also know that people have Fourth Amendment rights. And for those reasons, we need to be sure that we're going to execute those warrants at a specific time when police officers can be seen, can be recognized, can be allowed to enter into the property. If they're doing no good, then the police have a larger investigation that's happening, and that's why they've gotten the search warrant in the first place. They should announce who they are and then go in.
So I consider the floor leader a friend, conscientious, thoughtful, surely here to do the right thing, which is why it's so painful to stand up and have to defend an amendment like this, because the time frame does none of those things. The time frame is codifying law, the rules by which a criminal can conduct their business. At best, if the floor leader believes that this should be policy, then sit down with law enforcement behind the scenes, behind closed doors, and lay out what you think are best practices, but don't signal to the entire state of Maryland criminals who deserve and should receive a warrant to give them every benefit of the doubt. So on the amendment, I support the amendment because the sponsor of the amendment laid out a reasonable conclusion, which is we're here to defend the rule of law. I've heard that tonight once before. This does nothing close to defending the rule of law, because to defend the rule of law, you need law enforcement to do their job. I support the amendment.
Madam Speaker.
Vice Chair of the committee.
Thank you, Madam Speaker. I would ask the body to reject this amendment. There is nothing in the language of the legislation that says, barring exigent circumstances, barring an emergency, that the police, that law enforcement could not go in the home outside the hours that are specified in the bill. My colleague and former Judiciary Committee member, whom I consider a friend, stood up and talked about Netflix and quoted some language from Netflix. Well, I'm going to quote Biggie Smalls, okay? If somebody comes in your house in the middle of the night at 3 a.m., which was quoted, the first thing that came to my mind was kicking the door, waving the 4-4. Who's waving the 4-4? Is it going to be the police, or is it going to be somebody jumping out of their bed because they think somebody's breaking into their home? That is how police officers get shot. That is how innocent children get shot. That is how innocent people get shot. That is how Breonna Taylor got shot. I would urge the body to reject this amendment. Thank you, Madam Speaker.
Madam Speaker.
Recognizing the gentleman from Frederick and maker of the amendment.
All right. So my two friends, previous committee, mentioned a very high-profile case, the Breonna Taylor case. And the chair mentioned several things that went wrong in that case. The officers did not follow procedure. Lots of mistakes were made, and there was a loss of life. And I think that this bill actually addresses some of those concerns at a later point. And I look forward to having that conversation. But we're not talking about police officers making mistakes after the hours outlined in this bill. We're talking about police officers doing things by the book during the appropriate time. I have outlined in a 10-minute online search dozens of real-life cases in Maryland with drugs, heroin, fentanyl, stolen guns, and sex-trafficked children. And successful search warrants have brought justice in those cases in our state, in every jurisdiction in our state. If I had more time and more paper, I'd print them all out and put them on everyone's desk. What we're asking for here is just some reasonableness. And I'll leave you with this. My mother used to say to me, Jess, nothing good comes after midnight. And I say that because these activities, these horrific activities that wreak havoc on our state, drugs, stolen guns, sex trafficking, don't happen between the friendly hours of 8 a.m. to 7 p.m. in most cases. And that's what we're trying to deal with here, folks. So again, I push the amendment. I ask a favor. Thank you.
Recognizing the gentleman from Prince George's County.
Thank you, Madam Speaker. To the maker of the amendment, I wanted to tell a brief Maryland story that dovetails with what the Vice Chair of the committee just said. It's about a man named Hernan Palma. Many of our colleagues from Montgomery County may be familiar. This happened last year. He's a firefighter for Montgomery County, and at 4:30 in the morning last year, the police bust into his house because they thought that he was a drug dealer, which he wasn't. His children weren't. His wife, who was suffering from kidney failure and other debilitating diseases, wasn't. But I just want to report what he said about what happened when they bust into his house in the middle of the night. To your point, nothing good happens after midnight. I had no doubt that the criminals were trying to take my daughter away or rob us. I don't know. He stepped out of his bedroom to see what was happening and found a gun pointed at his chest. According to what the family's lawyer said, that he was pinned against a wall, handcuffed, and punched in the face in his home. Now, he didn't wake up, grab a firearm, and start shooting. But what happens often in these cases, when people bust into folks' home in the middle of the night, it puts you on alert. Because the first thing you're going to do, the first thing I would do, if someone came into my house, is think, I need to protect my family. Because I have no clue who's coming in. And you're assuming, a reasonable person would assume, if someone's busting into your house in the middle of the night, it's not for a good reason. It's not someone that's friendly. I think the committee has done an amazing job. It's given exigent circumstances. So if need be, folks can come in there. But they have to show that they have proof, not just some reasonable basis. They have to know for a fact what they need is in there. Because these instances are dangerous. They are very, very dangerous for the officers themselves and the people. And too often they bust in there and they don't find what they assume is going to be inside. And you have stories like the Palma family now, a firefighter and a family that will never forget this instance. I think we should reject this amendment. I don't stand often. I just think that the committee has done an amazing job here, and we need to follow the process that they put forward. Thank you, Madam Speaker.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Oh, okay. All right. Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails.
Madam Speaker,
Recognizing the gentleman from Frederick.
have any amendment at the desk? The number is 213-1231.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Okay, this amendment deals with page 6, lines 1 through 2, and it deals with the changing of the standard when applying for a no-knock warrant. So currently, the standard is a preponderance of evidence, or what's called a reasonable standard. So for example, if a law enforcement agency has evidence that more likely than not, there are, like we talked about, drugs, guns, children, they can apply for a no-knock warrant. What this bill does is it changes the standard to now what's considered a clear and convincing standard. And let me explain what other things are clear and convincing. For example, if you were to try to get off death row, you have to prove a clear and convincing standard. If you needed to remove someone from life support, clear and convincing standard is required. If you wanted to put someone in a mental hospital, clear and convincing standard is required. Or changes in child custody. These are some pretty heavy things. And I bring that up because what this bill does is it makes it almost impossible to get a no-knock warrant. The other thing that was in the bill, there's typically two categories where you could apply for a no-knock warrant. One, there's danger to people, to life, whether that's an officer or to a victim or somebody else. The other is when you fear someone is going to dispose of whatever contraband they have. That's the purpose of a no-knock warrant. If everyone knew you're coming, they're going to flush the drugs down the toilet. They're going to let the human trafficking victims out the back door. They're going to get rid of the stolen guns. That's why there is a no-knock warrant. If you tell them they're coming, they're going to make some moves. This bill removes all the property out of the no-knock provision. My amendment just changes the standard back to preponderance of evidence. Because when something is more likely than not a crime against our state, whether again that deals with drugs, stolen guns, human trafficking, we need the ability to have a search warrant. This bill is basically gutting the no-knock provisions in our law. I ask that you move the amendment.
Recognizing the committee chair.
Thank you very much, Madam Speaker. What this bill does is it puts stronger guidelines on no-knock warrants. It is responsibly moving forward our policy with regard to no-knock warrants, which deserve a higher standard than just a preponderance of the evidence. With a no-knock warrant, the officers are at your door and they're coming in. They're coming in. They're coming in regardless, in some cases, of a Fourth Amendment right here. They are coming into your house. And I understand that, people are going to say, well, they're criminals and they're suspects and we should be able to go in whenever we want. The reality is they're Americans. They have constitutional rights. And we are right to say that if you're going to enter somebody's house without any warning, that we expect more. We expect you to have clear and convincing evidence. We expect in this bill that there's even more than, to some degree, there's even more than that. We want you to explain the investigative activities that you've undertaken to justify this higher level search warrant. This is not just an ordinary search warrant. This is a big deal. That's why we raised the standard, and that's why we put additional restrictions on it. And I'll say it again. The warrant, if memory serves, with Breonna Taylor, was a no-knock warrant. It's important for us to make sure that those are issued rarely and with really good reason. That's what this bill does, and that's why I'll be resisting this amendment.
Madam Speaker.
Maker of the motion.
I will tell you, I like to think that I love the Constitution more than the average guy in this chamber. But if I believed it was about that, you wouldn't have stricken out the portion dealing with property, because the main reason to have a no-knock warrant is so that people don't get rid of all of the criminal evidence. So that people don't get rid of the stolen guns. So that people don't have time to flush the drugs down the toilet. That's the reason for a no-knock warrant. So if you strip that out, you've basically gutted the whole thing. So again, I ask that you move the amendment.
Recognizing the gentleman from Charles.
Thank you, Madam Speaker. Colleagues, I ask that we oppose this amendment. Maybe there's a little misunderstanding about what a no-knock warrant is when you serve it. It's a form of CQB, close quarters battle and combat. It's precise and surgical clearing, speed, surprise, and violence of action, which is the unrestricted use of strength and aggression to achieve total dominance against your enemy. Oftentimes disregards the actual threat. The possibility of deadly force increases greatly. It should be reserved for the most extreme dangers. You got to know the number of people on your fire team, shape of the room. You have to check your corners. I've done this. I've lived this. You put your life at risk every time. What this bill did, and I'm proud to say, is say that protecting evidence is not enough to risk a life. And number one, shut off the electricity. Shut off the water. It's not hard to stop an individual from getting rid of the evidence. But that evidence, that cocaine, is not as important as the lives of the possible children, adults, or police officers serving this warrant. This is nothing to be laughed at. This is nothing to be scoffed at. This is not magic. It is a dangerous, close quarters combat situation each time. And I'll say this. I've been on both sides of the fence. And one thing I'll tell you is when an individual kicks in your door, if you are someone who's dealing illicit activities, drugs, you're worried about it being another drug dealer or somebody robbing you. Nobody wants to get into a fight with officers with ballistic vests, shields, MP5s, MP45s, and P90s. That would eviscerate you, no matter how tough you may be on the street. So when those shots start ringing out, it's because they believe they're being robbed, attacked, and that they're going to be killed. This simply tries to avoid that by saying, evidence is not enough. We'll secure that another way. And by making sure that people understand that in America, we really have this vitally important thing called the Fourth Amendment. In fact, our forefathers said the right for people to be secure in their homes, properties, and papers was sacrosanct. They considered it a natural right, which is one granted by God. The house of everyone is his castle and fortress, and his defense against injury and violence. So the menial standard preponderance of evidence, which is the lowest standard of proof, basically means more likely than not. You don't even have to be totally convinced legally. It's not enough for them to violate my sanctity of my home. There's something more that's needed. Clear and convincing evidence is a highly and substantially more likely to be true than untrue. Isn't that what you'd want if you've been accused of owning too many guns? If somebody said you had a bump stock and they saw you buy it? If somebody says you've been selling AR-15s out of the back of your truck? Don't you want something more than a mere mention? And 50%, 51, let's go in that house and see what goes on. And if you're one of those armed individuals, if somebody kicks in your door at night, what is your response going to be? If you have AR-15s, if you have shotguns, what is your response? In your mind, you're not a criminal, so it can't be the cops. It's got to be the bad guy. And that's why they call it violence of action. So we need a higher standard for you to get in my home. Not just somebody saying what they think I've done. And that's what this bill does. I'm proud to say, and he gets rid of that evidentiary. That was one of my big sticking points. It is not worth the life. I don't care how much cocaine. We'll get him again. But it's not worth the life of the cops or the people inside. So I ask that you resist this amendment. Thank you.
Recognizing the gentleman from Carolyn.
Thank you, Madam Speaker. Now, I'm not an attorney, but as far as I know, a knock or a no-knock warrant is still a warrant, right? We're still not violating anyone's Fourth Amendment rights either way. Am I wrong or am I incorrect? And I do want to ask the question first before I continue.
So,
Committee Chair.
Give me your question again, please.
So whether we knock on the door or not, they still have, these police officers still have to obtain a warrant. Is that correct?
If
They just can't show up to somebody's house and just barge in and do whatever they want.
Correct. You have to get a warrant, and this area of the law in the criminal procedure article is how you would go and get the portion that the gentleman from Frederick is referencing is the part of the article that deals with the no-knock warrant.
So if they go get a no-knock warrant, how are they violating the Fourth Amendment if they're still getting a warrant?
I'm saying that they're getting a warrant, but if you're going in without knocking and announcing first, that is a standard. That is a far higher standard. It should require a far higher standard, because an ordinary search warrant does require you to announce yourself before you go into the property.
Okay.
This requires the higher standard because it doesn't require you to announce yourself before you go into the property.
I just wanted to clarify that no-knock warrants are constitutional, that they are not a violation of your Fourth Amendment.
No, that's right. No-knock warrants are constitutional. It's just the issue here is the standard by which you get a no-knock warrant.
Madam Speaker, I want to make one more point as well. I don't have any further questions. The point that I want to make also is the fact that this is not as prevalent as we may think. There aren't shootouts every single day here in Maryland. We're not citing example after example of police officers abusing these no-knock warrants. And in fact, nobody's saying that, well, we can cite thousands over the course of the history of Maryland. We can't even cite that there's hundreds. We can't even cite that there's dozens. Heck, we're not even citing that there's one in Maryland. We're citing a case in Kentucky, for crying out loud. This is what we're trying to prevent. This is what this bill is trying to prevent, a situation in 3 states over that happened. Unfortunately, I don't know that it's responsible to legislate on situations that may or may not happen, unless it's a real problem, unless it's a prevalent problem that has to be addressed. Thank you, Madam Speaker.
Recognizing the gentleman from Charles.
Thank you, Madam Speaker. I just briefly on the use of no-knock warrants. I'm a defense attorney. I was a prosecutor, for those of y'all that don't know by now. Every single drug search warrant in my catalog of cases was a no-knock warrant. Because what do they say? What is it? If you've got drugs, then you've got guns. So this is used all the time. Shockingly, because there's an automatic assumption that if you've got guns or drugs, then you have guns, and then they use that no-knock warrant. And again, every single time I tried to lay it out, I didn't want to be dramatic, but the situation, when that violence of action occurs, is horrific and dangerous, and you pray that nobody gets killed. To say this isn't used is a huge understatement. I am a lawyer. I know how often this is used. Every time there's a word drugs, and God forbid they say fentanyl or heroin, they're coming in with a no-knock warrant. And that is putting people by MP5 with a shield, bashing the door in, no chance to answer. That's a danger we can avoid today. Thank you.
Madam Speaker.
Recognizing the maker of the amendment.
Well, first, I want to recognize and thank the gentleman from Charles for his service. I come from a big military family, so I definitely respect that. He knows that. But, this bill also deals with SWAT. It's a big bill. So we'll have an opportunity to have that discussion as well. I move the amendment. Thank you.
On the amendment, all in favor signify by saying aye. Opposed? No.
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails.
Madam Speaker.
Recognizing the gentleman from Frederick.
I have an amendment at the desk. 223-9211.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you. This amendment strikes a provision in the most recent amendment to the bill. And I'll just explain it in layman's terms. For a regular search warrant, there is a now 30-second delay that law enforcement has to wait and give the occupants of a residence to answer the door. Now, this is problematic for a few reasons. As I outlined before, the bill strips property out of a no-knock warrant. So there's no option to apply for a no-knock warrant for the purposes of drugs, guns, other criminal enterprises. So they're now forced to apply for a regular warrant, which means when they go to a house for drugs, stolen guns, criminal paraphernalia, they have to wait 30 seconds after knocking on the door. Now, why would we want to give criminals a head start? Why would we want to give them 30 seconds to do whatever they need to do with the drugs, the potential guns, maybe people, maybe traffic victims? When you couple those two amendments together, that's what we have. We have a situation where you have a warrant, you're knocking on the door, and you have to wait. The Supreme Court has actually addressed this issue. In United States v. Banks, 2003, the Supreme Court heard a case about the time frame. Someone challenged it, a drug dealer, said that they didn't have the right to enter his place before he could dispose of the drugs. And the Supreme Court, quote, held that 10 to 15 seconds was enough time to satisfy someone's Fourth Amendment rights. That's the highest court in the land, folks. They also pointed out that any more time would be enough time to flush all the drugs down the toilet. Why are we giving them time to do this? Why? I just pointed out dozens of cases in this state where we've had successful search warrants and seized an ungodly amount of drugs, stolen guns, and saved lives. All over our state, every jurisdiction. That's what this is about. And I realize that there are cases, we just heard one, Breonna Taylor, where a lot of mistakes were made and someone lost their lives, and that's unacceptable. But mistakes were made. This bill addresses those in the later parts. We're attempting to throw out the baby with the bathwater here. I do not want to have a bill that creates safe havens for drug dealers in this state. I don't want to have a bill that creates safe havens for people that traffic guns or traffic people or children. So this amendment strikes the 30-second rule, and I ask you to move it. Thank you.
Recognizing the committee chair.
Thank you, Madam Speaker. I'd ask the body to resist the amendment. 30 seconds is a reasonable amount of time for a warrant to be executed. The Supreme Court said in that case that the officers waited between 15 and 20 seconds. 30 seconds is completely reasonable to give the person the opportunity to answer the door when the police officers announce that they are there and that they are there to serve a warrant. Let's go a step further. If they're going to execute a search warrant, they're probably not there by themselves in all likelihood. They're probably at the front door, at the back door, all the way around the house, outside the sleeping porch on the side. I don't have a sleeping porch. I hear they're nice. They're all the way around the house. They're watching who is coming in and out of the house. As the member from Charles County indicated, they've turned off the power. They've turned off the water. And they can see who's being shuttled in and out of the house. What we want to make sure that is being done is that they've reconnoitered the situation, they understand the situation, and that they're executing the warrant appropriately. That's what this whole section of the bill is about. And because they've done that, and they know the ins and outs of the building, they know who they're looking for, they know what they're going to get, it is far less likely that somebody's going to die. That's what we're talking about. I don't believe that 30 seconds is unreasonable, and for that reason I ask the body to resist the amendment.
Recognizing the minority whip.
Thank you, Madam Speaker. With all due respect to my good friend, this does create safe haven. So let's back up. We, a few lines earlier, passed the Beauty Sleep for Criminals Act that lets them make sure they don't get a warrant executed upon them after 7 or before 8 a.m. So now we're talking about between 8 a.m. and 7 p.m., and the police have a warrant, and now they're, coming, which this is great. They're in a recognizable, identifiable police officer. That's good. They show up at the door, and I'm going to actually time 30 seconds for you. Police, this is Officer Shalega at your door. In the meantime, the criminal is running around. You may have turned the water off, but there's still water in the toilet. You know how that works. We're at 15 seconds. Now they're running to get their gun and potentially shoot at the officers at the door. Plenty can happen in 30 seconds. I support this amendment, and now I can enter.
The committee chair.
Thank you, Madam Speaker. And what this bill further does is it says that those officers who are at the door are well trained. They're trained to do exactly what they need to do to be able to go into the house. They know where to look. They know where these items are hidden, where these items are secreted. They know because they have been professionally trained. They have gone and done the work that they need to do to make sure that they have a search warrant to enter somebody's house and to do it the right way. That's what we're doing in this bill, and that's why I believe the amendment, I would resist the amendment. Thank you, Madam Speaker.
Okay. On the amendment, all in favor signify by saying aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. The gentleman from Montgomery in the annex.
Thank you, Madam Speaker. I have a question for the floor leader. And before the floor leader rises, I want to thank you, Madam Speaker, for your leadership on this issue. It's certainly an issue that is way past time that we addressed. And I think it is good that we in Maryland are looking at this issue holistically and ensuring that we're providing as much as we can to the communities who are most impacted. And I think a good bit of that is reflected in 670, and I want to thank you for your leadership and the committee, the House Judiciary Committee, for all their work on this, which includes adopting Anton's Law into the overall House Bill 670. With that, a question for the floor leader, Madam Speaker.
Floor leader, Vice Chair of the committee.
Thank you, Madam Speaker.
Madam Floor Leader, can you speak to what in this bill addresses community oversight and control?
Yes, so thank you for the question. So first I want to thank the work group who worked diligently and very hard since May, so for about 11 months. It was a bipartisan effort, so I want to thank everybody. I want to thank the Public Safety Committee and the Judiciary Committee who worked all hours for a few days on the bill, and then the Judiciary Committee overall. And at the forefront of that was the idea of community oversight and transparency. And it's actually all throughout the bill, if you've taken a look and read the bill. So at the first stage, if we're talking about the disciplinary process, when a citizen files a complaint against a police officer, it goes to an independent investigative agency. And then it goes to a charging committee. That charging committee is made up of 5 civilians who take a look at the complaint, they take a look at the findings of the investigation, and it's the 5 civilians who make a decision whether or not that officer should be administratively charged. The legislation also provides for a police accountability board in every jurisdiction in the state of Maryland, which would be appointed by your county council or the mayor of the city of Baltimore. And that police accountability board is made up of citizens. And that is also an opportunity where a civilian can file a complaint against an officer if they so choose. The police accountability board works with the charging committee, has oversight over the disciplinary process, and works with the police department to make policy changes. If the officer is charged, if the charging committee decides to go forward with charges, the officer can accept those charges. If the officer decides not to accept those charges, then the matter moves forward to a trial board. And at that time, there's also opportunity for civilian oversight and participation. You will have 3 people on the trial board. One is a retired judicial officer or a retired administrative law judge, a civilian from the jurisdiction, and also an officer of equal rank. So there are 3 stages in this piece of legislation where civilians participate in the process.
All right, thank you, Madam Floor Leader. Madam Speaker, I have an amendment at the desk.
What is the amendment number?
The amendment is 713829/1.
Amendment number 1.
Thank you, Madam Speaker. Colleagues, over the past couple of years, a number of folks have been throwing around a particular term called reimagining public safety. And when we talk about reimagining public safety, to communities most impacted, it must mean transparency, it must mean accountability, and it must mean community oversight and control over the way public safety is administered in their communities. And this is not an uncommon idea. It is not a novel idea. It is an idea that jurisdictions across the United States are looking at or have already implemented. And as I asked earlier about community oversight and control, the floor leader shared about the civilian charging committees that are made up of civilians. In other words, having civilian participation in these charging committees. And I want to make clear that there's a difference, there's a distinction, colleagues, between civilian participation and community oversight and control over the way public safety is administered in their communities. If we are trying to reimagine public safety, reimagining public safety looks like giving the community the control and the subpoena, investigative and disciplinary power, which is what my amendment is calling for, that in essence would allow local counties to adopt a law or ordinance that provides a police accountability board with such powers so that they have control and are able to not only hold corrupt and abusive law enforcement accountable, but to make those communities whole through that accountability process. This is a reasonable amendment because what we are doing is putting the power back in the communities who historically have not had it. That is what we're attempting to do here. Are we placing in the hands of the communities most impacted the ability to oversee and control their law enforcement agency? And while I think 670 does a number of great things, particularly as it relates to transparency and the LEOBR, I think community oversight and control is a critical piece that we must include in all of this. And so my amendment that would allow local jurisdictions to be able to do that gets at the heart of the concerns of what communities have been calling for a very long time. And that call is very simple. We should be able to control the way that law enforcement not only patrol in our streets, but when harm is done to our communities, who are the people that are in a position of power to be able to make those communities whole again through the accountability process? And civil participation does not add up to what it is that we're calling for. I will give an example. In Baltimore City, there's been a civilian review board for a number of years. And it is known as pretty much a pit bull without teeth, because while there is civilian participation on the civilian review board in Baltimore City, the civilian review board does not have the powers that communities have for too long been asking of us, the very people in power, to empower them. And so, because we have not done what this amendment is calling for that I submitted, civilian review boards like that in Baltimore City don't necessarily have that power in order to hold police accountable. And I think that's what we're all trying to do here. We're trying to ensure that communities have trust in law enforcement, and we are bridging that divide. And the way we do that is not by providing less, but more community oversight and control, and putting that power in the hands of the community. I will add, because the floor leader mentioned it, about the role of civilians in this particular process. And the role of the civilian really only comes in when an officer refuses to accept a punishment from the police chief. So what kind of a community oversight and control are we providing when we have civilian participation with not the power that communities are calling for, and are coming into the process, are coming into play after the fact? That's not what community oversight and control looks like, and it's certainly not what impacted communities have been calling for a very long time. And I think with this amendment, we can not only strengthen the bill, but we could do something that communities have been asking us to do for a very long time. I think it is fair, I think it is reasonable, and it gets to the heart of what it is that we would like to see. Communities being able to hold their local law enforcement agency accountable. This is what impacted communities have been calling for a very long time. Not just now, but for decades. From civil rights and racial justice groups calling for civilian review boards with subpoena powers, Maryland has that opportunity to do that by accepting this amendment so that communities do have that say. But there is a very clear distinction between civilian participation, which is what the good delegate was talking about when she was explaining the process. And I'm all for civilian participation, but civilian participation on a committee or any board, when that committee or board does not have the power to actually hold law enforcement accountable, really gives this veneer that somehow there is community control. And we don't want the appearance of community control. We want actual community oversight and actual community control by the communities that are most impacted. This is a reasonable amendment, colleagues. I believe it strengthens the bill. I think it puts the power back into the hands of the people who, quite frankly, it should be in, and it should have been in for a very long time. And with that, Madam Speaker, I move the amendment.
Vice Chair of the committee.
Thank you, Madam Speaker. And I want to be clear. This bill puts the charging decision, whether or not to charge, in the hands of citizens. It puts the investigation in the hands of citizens. And it puts the punishment in the hands of citizens. There was a statement that was made that was just patently untrue, and if you read the bill, you'll see that it's untrue. The statement was made that civilian participation only comes into play if the officer accepts punishment. That's not true. At the beginning, at the charging committee, there are 5 citizens that determine whether or not the officer should be charged with a disciplinary action. 5 citizens. You can't get much more citizen participation than that. It's not until the officer refuses to accept the punishment and you move to the next step, the trial board, there's citizens on the trial board. And then in each jurisdiction, the police accountability has citizen oversight. And the chair of the police accountability in each jurisdiction sits on the charging committee. You cannot get a stronger bill with citizen participation and oversight in the disciplinary process for transparency than this bill. I also want to clear something else up that was said. The statement was made that Baltimore City has had a citizen review board for several years, and that's untrue as well. And I know that because I was here for the first police accountability and reform work group in 2015, I think it was. And at that time, the recommendation was that each jurisdiction should have one. We learned in the work group, which the good delegate sat on, we learned in the work group that that didn't happen until a year or so ago. So that just happened, okay? And the reason we're putting it into legislation and mandating it is because in 2015, when we said that was a best practice, no one did it. No one did it. So now we're putting it into legislation. I would urge the body to reject this amendment. The amendment was presented in the Judicial Proceedings Committee, in the Senate, and it was rejected there, and I would urge this body to reject it as well.
Gentleman from Charles.
Thank you, Madam Speaker. I just want to clarify a couple of things in my remarks.
The gentleman from Charles has the floor.
Thank you, Madam Speaker. If I could ask the Maker Amendment a few questions.
Go right ahead, Delegate.
Thank you very much. So we understand that you, each counties would appoint a local board, correct?
This would give local counties the ability to choose whether to create those police accountability boards and to provide them with those investigatory, subpoena, disciplinary powers. Again, it empowers the locality to be able to do that.
Okay, so how many people would be on this board in each county?
So I think it would be made up of the community. The amount of people we can certainly determine, I think that is based on size. We know we have bigger jurisdictions and smaller jurisdictions in Maryland, so it would really vary.
But it doesn't say so in your amendment, does it? It doesn't identify a number, does it?
Because I'm giving the opportunity for us to decide depending on localities, you know. So for instance, maybe Somerset County may not need 7 people on a community oversight board or police accountability board compared to another jurisdiction. And so I would say that I've provided us with the flexibility to have that discussion and to make that determination, Delegate.
But by your amendment, it's not us who will be making that determination. It would be each individual county would decide how many members were on, correct?
And I think we're putting it in the hands of the locality.
So that's a yes. Now, let's go on to the membership. What's the background requirements for these individual members? Is there one?
What this bill does is it empowers localities to be able to create and empower them with those powers.
So that's a no.
It allows those localities to make that determination. And I think the intricacies of what a community oversight and control board looks like is something that should be decided locally, but we should certainly give them the power to be able to make those decisions and to really control and oversee law enforcement agencies.
So what about training or education? Is there any requirements for your training or education in your amendment for these members?
The only requirement is that we not only have civilian participation, but real civilian power. I think communities have an understanding of how to ensure that public safety is administered in their communities, and we should put that power in the hands of the people, Delegate.
So depending on the jurisdiction, that could be an entire board that consists of all retired police officers, couldn't it?
I think in any jurisdiction, that would be for the locality to decide.
So depending on the locality you live in, as an African American who has problems with a police officer, you may get treated differently if your amendment is accepted, wouldn't you?
I think what we would do is give people the power. That is what we're here to do. It's about community oversight and control, not civilian participation. People being in a room but not necessarily having the power to decide is not community oversight and control. Now, either we believe that belongs in the hands of the people, or it belongs in the hands of 5 people who are appointed by government agencies, which is what this current bill would call for. 5 people who are appointed by government agencies and not the community. That's not community oversight.
So who appoints again in your bill? Because it sounds like a government agency appoints in your bill as well, in your amendment.
This empowers localities to create and to provide those police accountability boards with that power if that locality
And who
decides.
appoints in that locality?
I'm sorry?
Who appoints the board in that locality?
This is about giving power to localities, Delegate.
I understand that, but who appoints the board? Please answer.
This is about putting it in the hands of localities, Delegate.
Yes,
I'm
who
not sure.
appoints the board members in each locality according to your amendment?
It would be your county council, your county commission, or whosoever the duly
So
elected person
we call that a government agency, though.
I'm
so
sorry?
it's still a government agency appointing.
It's still a government agency.
Thank you.
that
Okay.
is- No, it's still a government agency that is deciding whether a police accountability board should not only be created, but have that power, right?
And they also do the
And
appointing.
all of these folks are duly elected. When we talk about an office of the public defender and a chief appointing someone, these are not elected people who are accountable to the community, and that's what it is about. By giving localities, county council, commissions, etc., these are people who are duly elected by the people. So once again, we are putting the power back in the hands of the people, and I don't see why we would be hesitant or in resistance to giving that power again to the people to determine how public safety is administered in their communities, and that's what my amendment would accomplish.
I understand the economy of words that you're using to answer my questions, but what it appears to be is that there is no standard for how many members. There's no standard from where they're picked other than that location, i.e. that county. They could all be picked from the same block. They could actually all be police officers or retired police officers or judges or former prosecutors under your amendment. And additionally, under your amendment, 24 counties, 24 totally different ways that my complaint would be treated. Whereas the bill without your amendment creates diversity of thought on each board. And I will say this, the people do have the power because we are duly elected. We're the ones making this decision. We're not robbing the people today because we choose to create this. We're putting a multitude of fail-safes in that include citizens. And we are duly elected. I ask to reject this amendment for all the things that I have laid out, the inconsistencies that this is guaranteed to lay out. The unfairnesses it will definitely create depending on the county that you're stopped in, the county that you complain in. The treatment police officers are going to get is going to vary wildly from jurisdiction to jurisdiction. We've heard the floor fights today, so we know how that's going to look depending on where you live. And I would like all the individuals in this state to be afforded the same joys, the same appreciations, and the same protections when they file a complaint. This amendment, colleagues, on the amendment, takes all that away. It makes it wildly inconsistent. It weakens what we're trying to do here today. And as I'll remind people, we are the people. I vote against this amendment. Thank you.
Madam Speaker.
The maker of the amendment.
Thank you, Madam Speaker. So I want to be clear on what my amendment would accomplish if we were to call a roll call and vote on this. But my amendment would provide communities with the oversight that they've been calling for. I would also add 90+ organizations from across the state that represent all of our constituents in here support what this amendment calls for. And it can only happen through local ordinance. This is what communities, particularly impacted communities, and mothers and parents and victims of police violence have been calling for. It's the kind of oversight and control that is meaningful, because we could talk about civilian participation and community oversight. Are we willing to provide meaningful community control and oversight of law enforcement agencies? And I think as of right now, the process that the good delegates have laid out in this bill is not sufficient in providing that kind of a community oversight and control, where we're talking about people being appointed by folks who aren't duly elected. We're talking about civilian participation and not the power to actually make communities whole through the accountability process. And that is what this is about. That is what communities have been calling for. We're putting the power in the hands of localities through local ordinance to make this decision. It is a reasonable amendment. It is one that we should all consider, because it's what communities have been calling for. It's what the Maryland Coalition for Justice and Police Accountability supports, and is what the Black Lives Matter, it is what a number of racial justice organizations have been calling for a really long time. It's about meaningful community oversight and reform. I will also add that earlier, the delegate had mentioned that I said something about when civilians come into play. My exact words were that these civilians don't come into play until an officer decides not to accept a discipline handed down by a police chief. Those were my words. And so what we're attempting to do is misrepresent the amendment, when what it does is provides communities with the control that they're asking for. It is that simple. And if we truly believe in holding law enforcement agencies accountable, then we will support this very reasonable amendment. Madam Speaker, I press the amendment.
Vice Chair of the committee.
Thank you, Madam Speaker. And again, it would have been nice if the good delegate had provided this ahead of time, but I would urge the body to reject this amendment. Words on the paper matter. Words that we put in this statute matter. And when you take a look at the words on this paper, as my good friend from Charles County said, it would create 24 different disciplinary structures across this state. And that is the opposite of what the work group and the Judiciary Committee intended to do. The intent is to create one Maryland, one policing structure for the entire state, so that the police and the citizens know what to expect. This amendment weakens the process. There's no diversity of thought in it, and I would urge the body to reject the amendment. I will end by saying that the good delegate corrected himself and said, my exact words were that citizens don't become part of the process until they reject discipline. Again, I will say for a third time, that is not true. If you read the words on the paper in the bill states that when a complaint is filed and there is an investigation, the charging committee, that's before an officer is even charged, so they haven't rejected anything. The charging committee is made up of 5 citizens who don't just provide oversight, as the delegate keeps saying, they are deciding discipline. They are reviewing the findings. They can decide that the investigation wasn't even that great and send it back. They can issue subpoenas. So that is citizen participation at the highest form, which is what he's talking about. Read the words on the paper, and I would urge you to reject this amendment.
Madam Speaker, if I may.
maker of the amendment.
Thank you, Madam Speaker. What I spoke to was not was the importance of community oversight and control. Civilian participation is important, but civilian participation without the power to adjudicate and to decide and to investigate is not meaningful community oversight and control. When we're talking about a civilian charging committee where 3 out of the 5 people are appointed, that is not community-centered and community oversight and control. The communities should have this power in order to determine that, and we should not be vesting it in a 5-person charging committee that is appointed. That is not community oversight and control. I believe my amendment gets to that. It is what communities have been calling for. It is what advocates are pushing for. It is what the Maryland Coalition for Justice and Police Accountability are calling for. And if we truly care about police transparency and accountability and giving that power back to those very same people, then we would seriously consider this amendment and pass it. Madam Speaker, thank you.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Gentleman's not supported. The amendment fails. Any other amendments?
I have an amendment at the desk, Madam Speaker.
The gentleman from
Yes,
Montgomery and Annex. Can you
Thank you, Madam Speaker.
Read the number, please.
I have an amendment at the desk. Amendment is 803-523/1.
Amendment number 1.
Colleagues, what this amendment would do, move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Colleagues, what this amendment would do is require the Attorney General in conjunction with the Secretary of State, the Attorney General in conjunction with the Maryland State Police to report to this General Assembly on certain information, to make that information available about the extent of white nationalism in law enforcement and within law enforcement agencies in our state. I think that data is particularly pertinent to what it is that we're talking about here when we talk about police transparency and accountability. And colleagues, I will bring to your attention something that I think would inform this debate that we're having and the consideration of this amendment. Maryland's own Congressman Jamie Raskin, who I think did a phenomenal job at making the case for impeachment, is the chair of the Subcommittee on Civil Rights and Civil Liberties in the Congress. And last year, his subcommittee, at the direction of Congressman Raskin, released an unredacted FBI assessment about white nationalism and the infiltration of white supremacy and white nationalism in law enforcement. And I invite colleagues to take a look at it. And what the report in essence showed is not only that white supremacy and white nationalism has infiltrated law enforcement, but that it has become an attractive profession because of the culture, because of the lack of transparency and accountability, but also the vetting process in terms of how law enforcement agencies hire and retain certain law enforcement officers. And what my amendment would do would ensure that we're gathering that information right here in Maryland, because what we know from the report from Maryland's own Congressman Jamie Raskin is that this is a serious problem nationally, and Maryland is certainly not exempt from that. What we need to ensure is that we're rooting out white nationalism and white supremacists from law enforcement if we ever hope to end racialized policing. What we know is that the inception of law enforcement in the United States comes out of white nationalism, and the very institutions that we see today have evolved from those very white nationalist beginnings. And if we can acknowledge that, then surely we know that white nationalism and white supremacy exists in law enforcement agencies, and it poses a threat to many members of our community. And so colleagues, this is not only a serious amendment, but I think it is something that we should consider as we're looking at the broader issue of police transparency and accountability, because what we know is that racialized policing is not only an issue, but because of current laws that allow corrupt and abusive law enforcement officials to get away with impunity, this has become an attractive profession for white supremacists and their sympathizers. And so what this does is it provides us with the information so that then we can take the necessary actions as a legislative body to ensure that we're remedying this. We will not see an end to racialized policing across our state if we do not address white supremacy and white nationalism within law enforcement, something that not only exists, not according to me, but according to an unredacted FBI assessment that I think warrants everyone's concern in this General Assembly. We cannot pretend to ignore that not only racism doesn't exist within law enforcement agencies, but white supremacy and white nationalism has found a home. And we cannot build trust between law enforcement and the broader communities that they serve if you have elements of white nationalism and white nationalists patrolling our streets. You cannot convince me that every segment of our society will feel comfortable with the fact that white nationalists feel comfortable within law enforcement agencies. This data is troubling, colleagues. And I invite you all to take a look at this report. And for the purposes of time, I can't speak to all of it, but it is deeply concerning. It is deeply concerning that we know in the United States of America, in every single state, that white supremacy and white nationalism has found a home. If we want to end racialized policing, we should adopt this amendment because it provides that information. It ensures that we can make better and informed decisions about ensuring that our departments are not just diversified, but is not an attractive place for white nationalists. This is what this amendment would accomplish, and I think it would be responsible of us as Maryland legislators to follow the lead of Maryland Congressman Jamie Raskin, who not only put out this information, but provides legislators, all of us, an opportunity to legislate around this very issue. And we have that opportunity to do this right now with the amendment, because it will not only provide that information, but it will put us on the right path in order to address this issue and address it properly. I brought this up in the House work group on police accountability that I was honored to be a part of. And while unfortunately we didn't consider it, my hope is that we would consider this amendment because it is very much a police transparency and accountability issue. It is very much a part of racialized policing. It is very much a part of the trust between law enforcement and communities. And it is very much about telling communities, Black, brown, LGBTQ+ communities, the Jewish community, that white nationalism has no place in our law enforcement agencies, and we will take the fiduciary responsibility vested in us by the Constitution to act on behalf of our constituents and to do what is right. With that, Madam Speaker, I move the amendment.
Vice Chair of the committee.
Thank you, Madam Speaker. I would ask the body to reject this amendment. Again, it would have been nice to have seen the amendment, and I'm in this box, so I don't have my computer with me. It would have been nice if the delegate would have provided it to the
It's a pretty simple amendment.
For consideration.
Please, excuse me. Maker of the amendment, the Vice Chair is speaking in response to your amendment. Please let her speak.
Thank you, Madam Speaker. So I would like the body to know that this was not brought up in the work group. Certainly, the work group considered and the work group took very seriously the issue of racism within the police departments in the state of Maryland. That was the whole purpose of the work group, to improve policing for our citizens and to, quite frankly, what seems to be getting lost in the conversation, to improve policing for our Black and brown officers that are in the state of Maryland. And so to that extent, in the legislation, you will see that we put implicit bias testing that are generally accepted by experts in the field of policing psychology as a requirement at the hiring process for current officers and training to that extent. At the hiring process, to root out the type of individual that the delegate was speaking of, and to require in current officers to undergo training if it was found that they did have bias. So to that extent, I would urge the body to reject this amendment. Thank you, Madam Speaker.
Madam Speaker.
The maker of the amendment.
Thank you, Madam Speaker. Colleagues, we cannot train and diversify our way out of systemic oppression, white supremacy, and white nationalism. It is impossible for us to train and diversify our way out of that. I completely agree. I think we need to ensure that those officers, black and brown officers, are certainly treated fairly on the job. But what I'm discussing is something that is separate. What we're talking about is white supremacy and white nationalism within law enforcement. And what we know is that exists. We know that exists as a result of an unredacted FBI assessment that was released last year by the Civil Rights and Civil Liberties Subcommittee that Congressman Jamie Raskin from Maryland chairs. And he ordered it because he felt like that information was not only necessary, but one that should spur us to action. What the good delegate is suggesting is that we train and diversify our way out of this very problem that this unredacted report has shown exists within law enforcement. And if the solution is to train and diversify, we are not truly rooting out white nationalism and white supremacy from law enforcement. And as a result, we are not ending racialized policing. That is what the amendment is designed to accomplish. And while things move quickly right here in the General Assembly, and we may not necessarily have time in order to discuss particular amendments, I think we have that opportunity right now in this very debate to have a discussion about this amendment, because that is what the people of Maryland expect from us. And what we're discussing right now is a very simple amendment that would instruct the Attorney General, the state police, as well as other folks in entities to gather this information and to report back to us, the General Assembly, the people that the good delegate from Charles County are vested with the power to be able to do something. What is wrong with getting that information so that we can better make decisions? Isn't that why we're here? We legislate based on the data. We legislate based on information. We legislate based on facts. And that's what that report has shown. It's not according to me. I invite everyone to take a look at this very troubling report. And I believe that this report warrants action by the Maryland General Assembly. I would say it warrants action by every elected official in power to be able to do something about racialized policing. We are in a position to be able to do that. And if we're looking at an omnibus bill that addresses police transparency and accountability, it would make sense to me that a reasonable amendment such as this to look at white nationalism and white supremacy. That is what we're saying here. If we reject an amendment, we're saying we don't even want information about the extent of white nationalism in law enforcement. Why would we want to bury our heads in the sand on an issue as important as this for the Jewish community, for the LGBTQ plus community, for Black and Latinx communities who we know are impacted by white nationalism?
Madam
and
Speaker,
white
point of order.
sympathies?
The gentleman is just repeating himself at this point over and over and over again.
Madam Speaker.
And it seems that violates our rules about
Madam
being
Speaker.
deleterious. How do you say that word? Deleterious?
Yeah.
Thank you.
Speaker.
Thank you, Madam Speaker.
On the amendment. Thank
Gentlemen,
you,
get
Madam
on
Speaker.
the amendment, please.
Thank you. I appreciate that. Deleterious, good delegate. But as I was saying, the amendment gets to that. And so we all have a responsibility to do that. The report has been put out there, and as legislators, it would really be an abdication of our responsibility if we don't truly address the issue of white nationalism within law enforcement, as this study calls for us to do. With that, Madam Speaker, I press the amendment.
Any other on the amendment? All in favor signify by saying aye. Opposed? No. The noes have it. The amendment fails. Any other amendments to the bill?
Yes, Madam Speaker, I have an amendment at the desk. It's Amendment 573721/1, Madam Speaker.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Colleagues, what this amendment would do is address an issue that for far too long has shielded law enforcement from the very accountability that communities have been calling for. What this amendment does is it ends qualified immunity in state courts. It ends qualified immunity in state courts for law enforcement official. It is something that a number of advocates and impacted communities have been calling for a long time. If we look at other states such as Colorado and even Florida right now considering ending qualified immunity, I think it's critical that as we're talking about police transparency and accountability, that we also address, which I believe the bill, as good as it is, did not address, which is ending qualified immunity. And so this amendment would do that to ensure that law enforcement aren't shielded by this judicial or legal doctrine that in essence says that they cannot be held liable civilly or criminally for their actions while on the job. And what that has led to is reckless endangerment and actions that have not only endangered the public, but have impacted communities. This is an amendment that I believe we should have considered and should have been a part of the overall package, but unfortunately was not included. But we have an opportunity to be able to do that right now. This is one of those demands from communities. This is what we should be doing because not only because it's the right thing to do, but it is right policy that shows communities that we are willing to dismantle the current laws that shield law enforcement from the very accountability, both legally as well as from the community. And with that, Madam Speaker, I move the amendment.
Floor Leader.
Thank you, Madam Speaker. Colleagues, I actually like conceptually what this amendment is trying to do, but let me tell you what we actually ended up putting into the bill. So there were several efforts to change how compensation is done for people who are injured or hurt by police misconduct. The parliamentarian had a bill, HB 1049. I had a bill, HB 721. There were a few others, and they dealt with a range of approaches. I haven't had the opportunity to see this amendment. Usually we get to see these in advance, so I'll just talk about qualified immunity broadly. What we did is this. Under current law, the maker of the amendment is correct. The individual officer is immunized, but the state or local government steps in as the person being sued, and the idea is that they have deeper pockets. So what we did was, in the under current law, you're capped at $400,000 for how much you can get if you're injured by the police. That's far less than you get if you're hit by a driver. So we bumped it to $890,000, more than doubling the compensation you get, and that actually would put a victim of police violence on par with the victim of a car crash. So with that change, that's actually what the people who bring these civil rights cases asked us to go for in the closing moments of us trying to get this bill out the door and on the floor for you to vote for. The other provision regarding getting the individual officer penalized to pay for it got a little bit confusing, but the bill, some of the bills that were introduced this year would have capped that at $25,000. So while I like the concept, getting $25,000 out of the individual officer, if they even have it, and you can collect it from them, versus the state and local governments who are insured and can readily issue payments and settlements, that made it into the bill. The parliamentarians' bill also had another provision, because we didn't want to let the officers just get off completely scot-free, that would have put their pensions in line to be forfeited for very serious misconduct. And there are a bunch of other things that we put into the bill. Immediate suspension without pay is a possibility to try and bring some level of individual accountability for those officers committing these wrongdoings. But I appreciate what the maker of the amendment is trying to do. We ran out of time. There were a lot of bills. There are at least another dozen minority party amendments coming on the bill. So I kind of think I appreciate this, but we got to get this show on the road. Thank you, Madam Speaker.
Just press the
Any
amendment,
further-
Madam Speaker.
Okay. Just pressing it here.
Just press the amendment, Madam Speaker.
All right. The question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. Noes have it. The amendment fails.
I have an amendment at the desk, Madam Speaker.
What is the amendment number?
Amendment number 243621/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So order.
Thank you, Madam Speaker. Colleagues, what this amendment would do is address an issue that I think is very much relevant to the police accountability conversation, and that is the issue of police or SROs in schools. What we've seen from the Maryland State Department of Education is that close to 70% of school-based arrests were for minor infractions. And what do I mean by minor infractions? 70% of school-based arrests were for disruption. It were for fighting, trespassing, drug-related offenses. 70% of school-based arrests were for minor infraction, and of that percentage, Black students accounted for a large portion of that. Black students account for a third of enrollment in Maryland public schools, but 56% of school-based arrests, as I mentioned earlier, for minor infractions. Oftentimes when we talk about the school-to-prison pipeline, what is neglected from that conversation is the role that SROs or police play in perpetuating that school-to-prison pipeline that siphons Black, brown, LGBTQ+, and students with disabilities from the classroom to the jailhouse. And that is reflected in the data that we're seeing here. In my own county, Montgomery County, Black students account for a fifth of enrollment in Montgomery County public schools and over half of all of its arrests. We are forcing young people to navigate a criminal legal system that not only undervalues them, that not only does not see their dignity, but is putting them on a pipeline that introduces them to a criminal legal system that will determine their life trajectory. What I'm hoping, since I believe it should have also been addressed in the education conversation, but since we're talking about police accountability, that we could address this issue. Because, as folks know, the General Assembly passed legislation around this issue. And what we have in essence done is sort of played a role in the kind of a data that we're seeing coming out from the SRO program in schools. A third of enrollment and 56% of arrests. What other demographic group would we accept this kind of a data for? We would not accept this data if in a particular school district, wealthy kids were being arrested at the rate that Black and brown and LGBTQ+ kids and kids with disabilities are being arrested. We would not accept this data if it had showed that white students or white children were being disproportionately impacted as a result of police or SROs in schools. But what the data is showing is that the people who are impacted are the people that look like me. And we cannot afford to ignore that data. And what this amendment would do is ensure that we are removing SROs from schools because, quite frankly, I think we should be investing in the evidence-based solutions that will keep all of our children in our schools safe. Safety doesn't always look like an armed person or an armed police officer patrolling streets or patrolling hallways. Understanding that these are officers and police as a matter of law. And they are charged with not only enforcing the law, but at times seeing the very people in these schools as criminals and as offenders. And I think we should see the inherent dignity of each and every one of our children, not criminals, but as children who are deserving of affirmation and support. And this amendment that I submitted would not only remove SROs from schools, but would allow us to invest in those very same evidence-based solutions. I move the amendment, Madam Speaker.
Chair of Ways and Means.
Thank you, Madam Speaker. There is a live bill in the Ways and Means Committee that includes most of the provisions that the delegate is speaking of today. So I say leave it to the Ways and Means Committee. Thank you.
Madam Speaker.
Madam Speaker.
Gentleman who made the amendment.
Thank you, Madam Speaker. As I said, from my county, which the good delegate and chair also represents, we see the troubling data that is coming out. This troubling data warrants action, and our inaction would only tell families, would only tell communities, and those young children who have been impacted as a result of being put in that school to prison pipeline. Those who are still dealing with the trauma, those who are still dealing with navigating a complex legal system, those who are still dealing with trauma. That is the reality of young people. And as I said earlier, we would not accept this data for any other demographic. What about Black, Brown, LGBTQ+, and children with disabilities that we are not willing to act? And that's really the fundamental question, because the data is troubling and it warrants action. I press the amendment, Madam Speaker.
Madam Speaker.
Gentleman from St. Mary's.
Thank you, Madam Speaker. Couple of questions for maker of the amendment.
Yes, Delegate.
I want to make sure I understand what your amendment does. So your amendment would ban SROs in the state of Maryland? Is that correct?
It would restrict as the amendment says, Delegate, it would restrict a local school system from contracting with certain law enforcement agencies to, in essence, have regular and routine armed officers patrolling schools. What it does not do is stop an administrator, a principal, or anyone from calling police to the school. What it does is it would end the regular and routine presence of police in our schools, because as the data shows, police presence in schools has a negative and disproportionate impact on Black, Latinx, LGBTQ+, and students with disabilities, according to the data from the Maryland Department of Education.
That was a long answer for yes. So, I mean, this kind of sticks with me because I don't know if you were here in the General Assembly at the time, but about 2 or 3, 4 years ago, we had a school shooting in St. Mary's County where the SRO stopped it and performed pretty well. So this kind of sticks to me that we were going to be forced to give up our SROs, and I think parents wouldn't agree with that. I do want to ask the maker of the amendment, because he's talked about a lot of data. Do you know how many students are in the school system, public school system in the state of Maryland?
I do not.
Okay, I pulled up some data here when you were offering your last amendment. I'm on the Department of Education site, and it says we have 800 and approximately, just a little over, and this is for the school year 2018 and 19. That's what all we had the latest data on. It says we have over 894,000 students in the state of Maryland in our public school system. Do you know how many have been arrested by SROs?
I know how many black students have been arrested by SROs, yes.
I can give you how many black students have been arrested by SROs, but do you know how many total students have been arrested by SROs?
I do not.
Okay. Well, that would be 2,628 students. 2,600, just a little over 2,600 out of 894,000 students. And the maker of the amendment asked about black students. That would be 1,766 out of the total 894,000 students. So you didn't know how many students we have. You didn't know how many kids were arrested by SROs, but now you're trying to ban SROs. I just got further questions for you. Do you have any idea how many might have been arrested for physical altercations in the schools? I'll give you that data. 732. Now, there's also was 25 arrested for sexual attacks. There was 20 arrested for sexual harassment. There was 11 arrested for guns, and for other weapons in our schools, there was 222. My question for you is, if the SRO isn't there, if we eliminate it, who takes those other weapons out of the schools? Who stops those sexual assaults?
So we have an opportunity to reimagine school safety that does not include an armed police officer constantly patrolling and seeing students as inherent criminals. What we know from the Maryland Department of Education is that it's close to 70% of school-based arrests are for minor infractions. And so if we remove SROs, we have an opportunity to then invest in the evidence-based solutions, which we already know what that is, whether it's beefing up security and controlled access at schools, whether it's investing in counselors, social workers, restorative justice practitioners, more nurses, the very people who can handle what it is that you're talking about. You do not always need an armed officer responding, and particularly to a concern that involves children. We have people who are able to do this. But what is the data is showing, and we have a responsibility to legislate based on data, is that it has a disproportionate impact on certain students. And if your argument is that, well, because it is a small portion, because it's only a little over 2,600 students that are arrested, and of that portion, X amount are arrested for X, and Y amount is arrested for Z, what we're saying that it is okay for a few students to have a traumatic experience that puts them in the school to prison pipeline because the numbers are so low. The goal here is to keep all of our kids safe, not some. Not a segment, not a few, all of our kids. And that requires us to think outside of the box and reimagine school safety that does not include an armed police officer, which, according to data, has shown that active shooters do not stay away from a school because there is an SRO posted there. So again, we can legislate based on data, or we can legislate based on emotions, because the delegate is talking about he's having an emotional defense to, the very amendment, when we can actually root it in the evidence-based solutions that will keep all, not some, all of our kids safe.
Madam Speaker, on the amendment.
On the amendment.
Woo, I won't make the mistake of asking more questions. Look, we could talk about data. I'm not making an emotional argument. I'm making a data-driven argument. And I guess maybe an emotional plea as well. I mean, this is important to my county. I mean, the SRO probably ended up saving some students a few years back when we had this incident. And the maker of the amendment doesn't seem to really know the data behind it. It just seems like a lot of rhetoric. Because when we were originally talking, when he answered the floor leader about Montgomery County, let's talk about Montgomery County a little bit. It's a huge county. It has 162,680 public students there. And the maker of the amendment said, well, half the students that were arrested were people of color. Well, here's the thing. There's 163 students arrested. 163 out of 162,000. And he's right, half of them are people of color. It was 73. 73, and only 30 people total in all Montgomery County schools were arrested by SROs. So we're asked, we need to start focusing on the victims and the people that are actually being protected by these good police officers in our schools. And we're asked to reimagine policing. Well, I'm asking the maker of the amendment to reimagine why the cops were there in the first place. Thank you, Madam Speaker. I urge a red vote on this amendment.
Madam
Thank you.
Speaker.
Madam Speaker.
The gentleman from Howard and Carroll.
Thank you, Madam Speaker. My wife often says that all of us want the same thing, but we end up getting stuck on debating the process. I believe that delegate who made this proposed amendment wants all of our students safe, but I disagree in the way that he is proposing to do so. Let's talk about police officers in schools, for example. The 2018 Maryland Safe to Learn Act unanimously passed the House and Senate, providing grant funding to any county wishing to robust their school resource officer program. That program is just getting off the ground now in 2021. Now these great police officers, our school SROs, are being drugged into this reform legislation. So let's talk about a typical SRO year. Take Glenelg High School, for example. There are 180 days in a typical school year, and an SRO could have a positive impact on those 1,200 students. That's 216,000 positive impacts in a given school year. In that same year, though, there were 4 people arrested who committed a hate crime. For the math people in the room, that's 99.998% no arrest, no school to prison pipeline, and positive interaction rate. I think we should shoot for 100%, but I don't want to start over at 0. Now let us talk about the victims of these crimes. Which one of these crimes would you not like the SRO to solve or stop? Because people on the other side say students enter the school to prison pipeline through normal behavior. Recently in Howard County, students were robbed, struck repeatedly in the head, and assaulted in bathrooms. Staff members and police were assaulted. A student's ex-boyfriend posted nude photos of her. A student ended up with a fractured spine. A student had an X-Acto knife held to his throat by another student. And finally, a student was sexually assaulted walking to the bathroom. Which one of these crimes are okay in normal behavior? Now, our great Howard County Police Chief, Lisa Myers, was recently quoted in the Baltimore Sun in an article about police reform. She said, "I would advocate for keeping SROs, as well as particularly looking at, from a youth perspective, how we institute more programs or initiatives that help better the relationships." She can see the need for improvement because we should always strive for better. But our chief and I would bet most parents would agree that we should strive to improve this program and not just remove our SROs. Finally, the state's attorney from Howard County just yesterday addressed the school to prison pipeline, and he said, from March 1, 2019 to March 31st, 2020, Howard County had approximately 255 police referrals. Out of those referrals, 24 were charged by the SRO, and 4 were charged by a regular patrol officer. The remainder of the cases were based on community referrals. Therefore, roughly 10% of the total juvenile cases examined by his office are coming from our schools, and roughly 90% are coming from the community. Therefore, in Howard County, it is overwhelmingly more likely that a juvenile enters the justice system due to robbing someone of their cell phone while on a bike path in Columbia than being charged for some interaction that occurred on school grounds. Facts matter for my constituents in Carroll and Howard County. The school to prison pipeline does not exist. Whom do people in Maryland hold responsible for the next fight that could have been prevented and resulted in a hospitalization? Or God forbid, the next school shooting, noting that last week we did have a school shooting in America, the same type of shooting that in the past inspired this great body to swiftly and unanimously pass the 2018 Maryland Safe to Learn Act. What then? Who is responsible? Thank you, Madam Speaker.
Madam Speaker.
Maker of the amendment.
Thank you, Madam Speaker, and I'll end with this. The data that I shared is what is coming out from our Department of Education. Low-level offenses, regardless of the amount of arrests in 1 year and the percentage of that accounts for Black and Brown and students with IEPs and LGBTQ plus student, any child that has to have a traumatic experience of not just being arrested, not just having to navigate a criminal legal system, not just seeing their education disrupted, one is too much. And what the data is showing, again, that warrants our action, is that there is a disproportionate impact, and we will not accept that for any other demographic, any other group. Why are we willing to accept it when the students that are coming up in the data are students that look like me? I press the amendment, Madam Speaker.
Gentleman from Charles.
Thank you, Madam Speaker. I'll try and be brief. It's always a very difficult, discussion. One I definitely believe is best left to the locals. But I'll say this, not every problem in a school needs an officer's response, but some do. My middle daughter is a junior with a 4.85, and she cannot have a backpack in school. She walks back and forth carrying a huge amount of books because she's taking college classes. Why do you think that is? Why do you think she can't have a backpack in school? Yes, because school shootings are still a threat in certain areas. They're still an issue. You know what her greatest issue is to me when she comes home? Dad, they keep leaving these back doors open. We've got one of the old schools, one of the schools that has open. They have like little open areas, because remember back in the day, they thought that was a good idea to not have walls in schools. We've learned that that's not true. We learned that that's not safe. But see, that's her school. Right now, the way her school is designed, the only thing that really is protecting her from that possible school shooting is our SRO. And again, this is a local issue, but it's not one I take lightly. Just because we haven't had one, that doesn't mean we're not going to have one. And I always ask people, we don't know how many school shootings an SRO stops. I love when they come out with evidence that they only stop a few. Remember this, every time there's a gun, it's for a reason. What do you think they carry a gun for, play? No, it's a possibility that it could be used in an act of violence. And it could be used at that school. And I, for one, have children in those schools. I don't want to villainize all law enforcement. I don't think by any means that the best way to deal with law enforcement is to move us as far away as possible. That way, when we finally run into one, we're absolutely terrified because all we go by is what we saw on TV. I stand opposed to this amendment because for a plethora of reasons. We've got other bills. It should be a local decision. But I also oppose it because as a parent, I know my daughter is terrified because she can't have a backpack. And if she can't have a backpack, she needs something else in the meantime until we solve that problem. Thank you. Oppose the amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will call the roll. The amendment fails. Gentleman from Anne Arundel in the annex.
Thank you, Madam Speaker. I have an amendment at the desk. amendment number 683220.
Amendment number 1.
Move so much to consider the reading of the amendment.
So ordered.
The amendment simply just strikes the following language from the bill. A police officer may not use force against an individual unless the force is necessary force and proportional to taking into consideration the seriousness of the alleged crime. Now, given that an officer is quickly assessing a large variety of factors when he or she is involved in looking at a possible criminal activity, and also given that these decisions need to be made in split seconds with very limited information. Seconds can save lives. We hear it all the time. Now, granted, science tells us the human brain has the ability to unconsciously process 11 million pieces of information per second. I know some of you guys look at me and think, there's no way that guy's breaking 10 million. But even knowing how powerful the human brain is, it is simply impossible for an officer to fully understand the seriousness of a crime in every situation and apply the proportionality of it. Consider this. Consider a police officer working on the street and he sees a purse snatched from a lady across the street. And the individual starts out on foot and the officer starts to pursue the individual. In the pursuit, the individual that stole the purse turns a corner and there's an 80-year-old woman there. Somebody just like your grandmother or my grandmother. And she gets knocked to the ground. But the police officer does not have time to stop. He's trying to apprehend the purse snatcher. He gets to the purse snatcher, and the purse snatcher resists arrest and starts to fight the officer. Well, the original crime of just stealing a purse is bad, but it's not the most serious crime. But what if the grandmother, who was knocked to the ground, sustained some sort of blunt injury to the head and could die? Then we have somebody that has lost their lives at the hands of this assailant. But the police officer doesn't know that. They never have that information readily available to them. Or another example, police officer's working and sees a drunk guy on the street. Drunk and disorderly, not a big deal, but the police officer goes to speak to the gentleman, and as he gets there, he takes off, and the police officer's got to chase him down. He gets to him. He resists arrest. Well, once again, it's just drunk and disorderly. Not that big of a crime. But what he doesn't know is an hour beforehand, he may have raped or murdered somebody. The cop has no idea of knowing what happened. So for those reasons, I urge the body to support this amendment that simply strikes this language. It is far too subjective, arbitrary, and unreasonable to believe that a police officer can make all these snap decisions, even with the power of the brain. It's just impossible to take all these things into account. A police officer should only use the force necessary to get them into custody. Nobody's asking for more than that, but we can't ask them to be all-knowing of everything that happens within a second of a crime scene. Ladies and gentlemen, I ask you to support this amendment.
Vice Chair of the committee.
Thank you, Madam Speaker. I would urge the body to resist this amendment. In the legislation, we are creating a use of force statute in the state of Maryland. And the purpose of that is to ensure that all 24 jurisdictions are using the same use of force standard. And the purpose of that is so that the police officers will know in each jurisdiction we're all operating under the same standard, and so that citizens will know the standard. You know, I live in Howard County. I easily travel to Burtonsville or here to Annapolis or to Prince George's County, and I should, as you should all know, what use of force standard to expect from the police. All we are saying here is that a police officer may not use force against a person unless the force is necessary and it's proportional. Now let's take the delegate's example of the grandmother purse being snatched. All that means is the officer, he can't pull out his gun and shoot the individual who's robbing the grandmother. That individual didn't have a gun in the example. He didn't have any weapon in that example. What we're saying here is that officers should not jump immediately to the top of the use of force continuum when trying to apprehend a suspect. It does not prevent an officer who is in imminent harm or an officer who is protecting another individual who is in imminent harm from using a weapon. It simply states that the officer has to use force that is proportional to the situation. And with that, I would urge the body to reject the amendment. Thank you, Madam Speaker.
Madam Speaker, I think it's safe to say that we could stay here and
Floor
exhaust.
leader, not the floor leader, the maker of the amendment.
Thank you, Madam Speaker. I think it's safe to say we could stay here all night long and exhaust different scenarios and situations, but the bottom line is it is almost impossible to make these snap decisions. I press the amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call,
No.
Madam Speaker.
Roll call.
Madam Speaker?
Clerk will call the roll. The amendment fails.
Madam Speaker.
Gentleman from Western Maryland in the back.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment 373620/1.
Amendment number 1.
Thank you, Madam Speaker. Colleagues, I know you've had a fascinating, interesting evening. We've been here for quite a while, and now we get to return to the law school portion of tonight's proceedings. Please stop being so excited. I can see the enjoyment in all of your faces, because I can see all of you from back here, and you seem very excited. One of my law school professors is actually sitting right here looking at me, my very good friend from Baltimore City, the delegate from Baltimore City, who was a professor of mine when I went to law school. So he will appreciate some of our conversation. The amendment that I'm offering at this time relates to something that we call in Latin mens rea. We like to have fancy Latin words as lawyers because we think other people don't know what we're talking about. It's kind of stupid, really. Mens rea basically just means intent, that you have to have intended for something to have happened. You have to have an intent for something to occur in order for the criminal law to punish you for it, to sanction you for it, to find you guilty of it. And what I think we may have done, perhaps inadvertently, perhaps deliberately, I'm not sure, in this bill tonight, what we may have done is made a mistake in leaving out a specific intent requirement that is going to subject law enforcement officers under the use of force statute, the use of force provision of this bill, to an extremely difficult and perhaps dangerous status for them, and put them in a situation where they could be prosecuted for things that really they should not be. What I'm pointing out to you is this. In Maryland law, first-degree murder, which is Section 201 of the Criminal Justice Article of the state of Maryland, requires intent. Second-degree murder, 2204, requires a form of intent. Now, there are some types of murders that you can be convicted of without specific intent to commit the murder, but they were murders that occurred during the commission of another felony. We call that felony murder. I'm robbing a store. I didn't intend to fire my gun, but I fired my gun on the way out of robbing the store. It struck and killed someone. I may be able to be prosecuted for murder. First degree assault, 3 Section 202 of the Criminal Code. It requires intent. So all of these specific crimes require a prosecutor to show, a judge or a jury to determine that there was an intent by an actor. And in the original iteration of this bill, and I had the privilege to serve on the Speaker's work group, and as my friend from Howard County who chaired the work group indicated, we spent many hours on Zoom. I'm sure that everyone can appreciate the limitations of Zoom. We spent many hours on Zoom this summer and early fall in this bill. And in the original iteration of the bill, it required knowing and willful action by the police officer to violate the use of force statute. It said that if the police officer knowingly and willfully violates the use of force statute, the use of force provision, then they could be subject to criminal sanction. For some reason, unknown to me, I don't serve on the Judiciary Committee, but for some reason during the process of this bill, what we had worked on in a bipartisan fashion to include that intent requirement was now taken out. And now an officer can be prosecuted for violating this use of force statute and using lethal force, which we define in the bill, and I'm reading from the bill. Lethal force means any force that creates a substantial risk of death or serious physical injury, and here are the key provision, whether or not intended to cause death or serious physical injury. So we have removed an intent or a mens rea requirement at law from the violation of the lethal force requirement. We've said lethal force does not require intent. Doesn't require it. It just requires you committed an action, and the action created the risk of death or serious physical injury as a police officer. It's a new definition within the law. But then the bill says that an officer who violates the use of force statute, an officer who uses lethal force, can then be convicted, and it lists 4 specific crimes. They can be convicted of murder, manslaughter, assault, or reckless endangerment. Well, what I just suggested to you is that to convict someone of murder requires them to have some form of specific intent. To convict someone of first-degree assault requires them to have some form of specific intent. But the way the bill has been modified and changed and drafted from what I thought was a pretty reasonable idea, I didn't love everything in the original bill that we produced from the work group, but I thought it was a very good work product. We've now changed that for some unknown reason, and we have created this convoluted process whereby in one section of the bill we're saying lethal force doesn't require any intent at all, but we're saying when you violate the use of force statute by using inappropriate lethal force, we can convict you under crimes that require specific intent. Now, not all of them. Manslaughter doesn't require specific intent. Second-degree assault often does not require specific intent. But I think the advocates of this bill may have unintentionally put themselves into a position where now a police officer who may be found to have exercised unlawful or inappropriate lethal force is now going to be prosecuted, and tricky defense attorneys, because defense attorneys can be tricky. That's their job. I myself am not really a criminal defense attorney, but I have respect for them. That is their constitutional job to come up with arguments. And I suspect that many of them, many good ones here in the state of Maryland, will come up with an argument and say, I'm defending a police officer who is now charged with a violation of the lethal force statute, and someone died or someone was seriously physically injured, and I'm going to make an argument that you cannot charge them with murder, that you cannot charge them second-degree murder, you cannot charge them with assault. All you can charge them with is second-degree assault or manslaughter or reckless endangerment. And I think that the advocates are going to be sorely disappointed when they realize that. What I am suggesting to you is what is fair, what is lawful, what is correct in hundreds of years of our jurisprudence stretching from the English common law that forms the basis of many Maryland laws and many Maryland criminal laws, is that you have to have intent. You can't take an individual and find that he or she is guilty of a law of this nature, a felony, a murder conviction, and you can't graft this lethal force definition into the law in a way that is inconsistent. And so what the amendment would do, quite simply, is it would restore the language that a violation of the lethal force statute would require the officer to have done so knowingly and willfully. And that's really what we're getting at, right? We're not getting at people who maybe just made a mistake. We're not getting at good faith actors who were trying to do their best to restrain someone and that person fell down a flight of steps. We're not getting at people who honestly, truly believed, that they had the ability to use a weapon or an implement to defend themselves or defend someone else and someone died. And then we Monday morning quarterback it weeks, months later and say, well, now we're going to charge you. We're trying to get with the people who knowingly and willfully, who in their mind said, I am going to violate the use of force statute, I am going to do something wrong. You want to penalize those people? I'm with you. You want to craft this statute the way it is? It's inconsistent, it's poorly worded, and it's going to be very difficult to enforce for the crimes, and you want to sweep up in that unknowing actors. I can't be with you. I hope that the body considers this amendment to be in good faith and in the spirit of improving the bill and improving our jurisprudence in the state of Maryland, and that the majority would consider it for inclusion in the bill. Thank you.
Chairman of the committee.
Thank you, Madam Speaker. I'd ask the body to resist the amendment. I don't know that I really want to go back to law school at all. But I thank the gentleman for sharing the amendment. I'll be relatively brief. With due respect, what the bill says and what is in the bill, it says that the officer can be charged. It does not say that the officer is going to be convicted. Those are two very, very different things. They still have to be convicted beyond a reasonable doubt. What the bill says is if they violate the use of force statute, they can be charged for these things. And that, I think, is a significant distinction. In his remarks, he said they're going to be convicted. That's not what the bill says, and that's not what the bill does. And Madam Speaker, with that, I'd like to yield to my colleague from Charles County.
Gentleman from Charles County.
Thank you, Madam Speaker. And colleagues, just honestly, Mr. Chairman said it wonderfully. This is just the beginning. This is just the probable cause for the charges. And as he said, now us crafty defense attorneys get to stand up and point out just how it was done and how it was not done intentionally. We get to use mens rea and all that. What this is, again, is just the beginning phase of this. There's still due process. This does not take away this individual's due process. All it does is start the procedure. I don't know if there's a misunderstanding that somehow if you're charged with something, you're going to get convicted, but I'm glad my clients don't believe that, because a charge is not guaranteed a conviction. But again, we have individuals here. Let's not forget who we're talking about. We're not talking about the good colleague here, a maker of the amendment, myself. We're talking about individuals we expect to be trained. We should have a higher expectation. We have this weird way we view law enforcement sometimes. Sometimes they're just like each and every one of us. And we say, oh, no, well, people make mistakes. But then there are other times like his word is bond. His word is law. If he says something, he can come into my house. He could stop me at work. He could take my children away. He could lock me up solely on his or her word. They're trained professionals. This is their job. This is their profession. We don't lower our standard. We raise it for individuals that we give a gun to protect and serve us. So yes, the way the law is written is very apropos. If anybody should know better, it's them. If it's anybody that should be trained better, it is them. If there's anybody that I have an expectation of knowing proportional force for the threat that's occurred, or not to put a knee on somebody's throat or shoot somebody running from behind, it would be them. Don't lower our standard for those that we have hired, we have paid to protect us. Let's keep it raised and oppose this amendment. Thank you, Madam Speaker.
The maker of the amendment.
Thank you, Madam Speaker. Very briefly, both of my colleagues and my friends who just spoke have been prosecutors. I believe the chairman of the committee still continues to be a prosecutor. I never have. But I know this. Prosecutors do not charge people. They should not charge people. They should not charge an individual from a community of color. They should not charge a police officer. They should not charge anyone with a crime that on the day they charge them, they know or suspect may not be lawful and appropriate because of the intent requirement. When we say, well, they're not going to be convicted, we'll just charge them with murder, and then their defense attorney will say, there's no requirement of intent in the lethal force statute, so you don't have the necessary predicate, the factual elements, the legal elements for the charge. Think about that. Imagine that someone is charged with murder and then told later, well, we can't really convict you of the murder legally. That's wrong. That's not the way the statute works, but we charged you with murder. We're going to charge you anyway. I don't care if it's a police officer. I don't care if it's an innocent individual in the streets. I don't care whoever it is. That's not the right way to do business. This amendment is very simple. It replaces knowing and willful language that was in the bill, was in the work group bill, was the intent, the bipartisan intent of the bill. It replaces that language and includes that requirement that exists in all of these other criminal statutes. And that's what we're creating here. We're creating a very specific criminal statute just for police officers to fit into, the lethal force, use of force statute. I think the amendment is sound. I appreciate the remarks of both of my friends, but I hope that the body seriously considers it. Thank you.
On the amendment, all in favor signify by saying aye.
Aye.
Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails.
Madam Speaker, I have one other amendment at the desk. Just one, I promise. For me, at least. I don't want to get anybody's hopes up, The amendment is 153323/1.
Amendment number 1.
Madam Speaker, thank you. This amendment also relates to the use of force statute. And it relates to this concept that we've created and we've grafted into the statute that in part I agree with, about how a police officer in the heat of the moment, in the performance of her or his duties, confronts and deals with a suspect or an individual that they feel that they have to restrain or that they have to attempt to detain. And it's about what is reasonable. All of us, again, it's law school hour, folks. All of us who went to law school heard the word reasonable used over and over and over again. Reasonable is a term of art in law. It applies in antitrust law, in tort law, negligence law, and in the criminal law. Someone's reasonable self-defense is what justifies them to be acquitted, not unreasonable self-defense. Someone's reasonable actions are protected under the law. And reasonable, we're all educated, intelligent individuals in this room. We understand that reasonable means human beings get to decide that. Human beings get to sit back, fact finders, judges, juries, they get to decide what is and what is not reasonable. There is a section of this bill that basically says that a police officer may not use lethal force against a person unless, and there's several predicates to it, before the section I'm talking about, lethal necessary force is used as a last resort to prevent imminent threat of death or serious physical injury. The use of lethal force presents no substantial risk of injury to a third person. And then the section that my amendment addresses. And this section says, I'm sorry, it's getting a little dark back here. Here's some key words, all reasonable alternatives to the use of deadly force have been exhausted. Now, when I hear that, I don't know what that means. I mean, that is such an incredibly high standard for a police officer on the streets. All reasonable means have been exhausted, completely exhausted. So I don't want to play the hypothetical game, but what does that mean? Does that mean when first I'm confronted by a potentially violent individual, I use my words? Please, stop, don't, get on the ground, drop the gun, drop the knife, let that person go. I use my words. And then when they don't do that, then what do? Then I try to grab a hold of them a little bit because I got to be reasonable. I got to exhaust. Let's think about what that word means. Exhaust. Maybe I try to grab them. Maybe I try to flex. I probably wouldn't be the best person for that. Maybe my friend from Charles County would be good at that. But I try to flex. I try to scare them. I'm like, come on, man. put that knife down. And they don't do that. And they continue to move on. And then what do? Do I have a beanbag gun? Do I have a taser? Do I take that out? What if that doesn't work? Well, I haven't exhausted yet. Now the individual's turning and coming toward me with an implement of violence, and I don't know what's going on. Maybe they're suffering from a mental breakdown, which is a terrible, tragic situation for everyone. Maybe they're under the influence of drugs. Maybe they're just a hardened criminal. It's hard to tell in that 30 seconds, or that 5 seconds, or that split second. And I sit there and like, at what point in time do I get to say I've exhausted all reasonable means and now I get to protect myself or protect someone else? All my amendment suggests, all it states, it doesn't remove the requirement entirely. It just takes away the all and the exhausted. And it basically would say that a police officer has a duty to act objectively, not just what he or she thought, but what society thinks, what a reasonable person thinks evaluating their actions, objectively to use reasonable alternatives to the use of deadly force. It says you can't start out, hey, this guy was just mouthing off to me 20 feet away, I pulled out my gun, and as soon as he mouthed off again, I shot him. That's ridiculous. That's repulsive. No one should tolerate that. But it does say that we're changing the statute and we're changing the standard from all and exhausted. I'll leave you with this. I've known a tremendous amount of police officers in my life. My father was a police officer. I really didn't know him as a police officer. He was only a police officer for a few years when I was very young. I have friends, relatives, neighbors, clients that are police officers. And they are not perfect, and they would not tell you that they are perfect, and they would not tell you that their profession is full of saints and absent of sinners. But in my personal experience, and I bet you it's really not that different, regardless of where we come from, the streets of Baltimore, the rural communities of Western Maryland or the Eastern Shore, the suburbs of D.C., I bet you if you really think about it, it's not that different of an experience in that almost all of the police officers you know, we walk around these buildings every day, and who do we see? We see men and women who are police officers. And they treat us wonderfully, and they protect us. In our communities, we see these people. What I have found, not without fail, but almost without fail, is that the men and women who serve us in law enforcement are trying to do their damn best when they leave to protect the people that they're sworn to protect and to come home at night to their loved ones. Those are their two objectives. Do my job, protect people, and come home at night. All I want to do with this amendment is not subject them to being the subject of lethal force complaints, to being the subject of criminal prosecutions, because someone somewhere says, well, you know, I determined that you didn't use all alternatives to lethal force. You didn't exhaust all of them before you pulled a trigger. I know a couple of police officers personally who have had to shoot someone in the performance of their duties. It was found to be a valid exercise of their authority. And I can tell you this, it has scarred them. I know the individuals and the families who were the victims of those shootings or who were involved in them. I know their loss is far more permanent and far more profound. But let's not imagine that these individuals do this willy-nilly, that they do it without compassion, and it doesn't affect them. All I want to do in this amendment, give them a little bit of protection that someone's not going to throw them under the bus because they determine you didn't use all means and you didn't exhaust all of them before you tried to protect yourself or protect one of us or one of our family members in a certain situation. That's all. Thank you, Madam Speaker.
Vice Chair of the committee.
Thank you, Madam Speaker, and I would like to thank my good friend from Allegheny County for his participation on the work group. I enjoyed looking at your pink wallpaper through Zoom. It's awesome. And I do want to thank you for providing us with the amendments ahead of time. When the work group started in May, one of the things that I said at the very beginning is that this is not about being anti-police. Just like the good delegate said, we all know police. My grandmother, she's 91. She was a retired sheriff right outside of Detroit, Michigan. This is not about being anti-police, but what this is about, and with all due respect, we don't all have the same experiences. The good delegate said all of our experiences are similar. That's not true. If you are black and brown in this country, in this nation, that's what this is about. Your experiences are just different, and that's a fact. And quite frankly, I don't think I realized that viscerally in my bones until I started raising children. I was treated differently than my brother. Since this national movement, since George Floyd has occurred, I've learned so many stories from my brother and my father about how they were treated by police that I guess my family decided to protect me from, about my brother being face down on the pavement around the corner from our house. What are you doing here? My dad being harassed driving from Montgomery County from his office to Howard County. What are you doing in this nice car? This is the experience of black and brown people in this country, and it is a fact. My oldest son is 9 years old, and he's huge. I don't know, I'm not huge, but he's huge. He's about to be taller than me. He's only 9, but I worry every day. Literally, I worry about how he's going to be treated when he goes out into society, that he is going to be misjudged by his age, and that people will be intimidated by his size, and that they will be scared and treat him differently because he is black. When he was 6, he attended camp for the first time. I was a nervous mother. The camp took him to Chuck E. Cheese. He thought, hey, we're going to Chuck E. Cheese. It's fair game. I can do whatever I want. He walks out with a toy, gets on the bus, didn't pay for the toy. In his mind, he thought the camp counselors took him there, he can do whatever he wants. This is a young man who gets whatever he wants. If I don't get it, his grandmother or great-grandmother sure do. The camp counselors took him back in, returned the toy, told me what happened. When he came home, I lit into him. I said, you cannot do that. You cannot do that because of the color of your skin, and it doesn't matter if you're 6. Just sit in our committee. You'll hear stories of little black boys getting caught up in the juvenile justice system for years. And that is what I told him. Mommy might not be able to get you back, so you need to understand how you need to behave out here in society because our experiences are different, and that is a fact. And that's what this bill is about. This bill is about all Marylanders, white, black, brown, being treated the same. That's all it's about. It's not anti-police. If you have the ability to take someone's life, you should be required to exhaust all possibilities, period. Your first reaction should not be to jump to lethal force. And one of the great things about this bill is that this continuum is focused on training. So officers who are trained from jump will hopefully not go through a checklist, but they'll be trained to not just automatically go to the most lethal option that they have. I would ask this body to reject this amendment. Thank you, Madam Speaker.
The gentleman from Ocean City.
Thank you, Madam Speaker. I'm learning something tonight about my colleagues, the good delegate here and the good delegate from Howard County. I too had a relative that was in law enforcement. It was my dad. And I can tell you my dad is a good person. I think he's a real good person. And he's compassionate and caring. And I can sit here and share a lot of stories with you, not only from him as a dad, but him as a member of law enforcement, how he's used care and compassion. And to think that him simply doing his job can make him a felon would be, it's insane to me to think that. Police officers, law enforcement, they're often forced into making split-second judgment decisions in circumstances that are tense, uncertain, and rapidly evolving. Think about this. When we leave here tonight, we all know it's going to be late. We're going to go over to our office. It's an environment we're all familiar with. We know it's relatively safe. But when you get in there, you're going to turn that light on. Now think about this. The member of law enforcement that's maybe running down a dark alley, an area that's certainly not familiar to him, cold, icy, slippery. And that member of law enforcement, he or she may be chasing somebody that might be twice their size. And that person they're chasing might be intoxicated or might be on a drug or another controlled substance. And that person may have a weapon. And it's in that moment that use of force may occur. And then after that happens, the member of law enforcement is going to be subject to the scrutiny of a Monday morning quarterback. Somebody sitting there the day after, scrutinizing that situation, every part of it. And for us to do that in this standard, it's unrealistic, it's unfair, and to have that person second guess in that split second decision is dangerous, not only for that person, that member of law enforcement, but for other members of the community. And I ask you to vote green on this amendment. Thank you, Madam Speaker.
Madam Speaker.
The maker of the amendment.
Very briefly, Madam Speaker, I intend to press the amendment. I just wanted to say that I sincerely appreciate the remarks from my friend from Howard County, and no one is suggesting that you or anyone that I'm aware of has put forth this bill because of an animosity towards police officers. I served with you on that work group, as we've said. I heard you tell the stories about your grandmother and being one of the first female minority police sheriff's chiefs in the state of Michigan. That was significant. I know that means something to you. No one, my amendment really doesn't have anything to do, however, with the issue of particularized policing or improper policing towards communities of color or minority communities. It is colorblind. It simply says that you have to provide a reasonable and objective view of what the officer did. It may be a female officer. It may be a female officer who is smaller potentially than an assailant, and that officer has to make decisions very quickly about what she can do in that circumstance to protect herself, to subdue the assailant, to protect someone else that she's coming to. And all that I want to do is provide a situation where that officer doesn't find herself the subject of someone looking back and saying, well, you might have been able to just kick the assailant in the leg rather than push the assailant into the wall, and when you pushed him into the wall, he hit his head and he was injured. You didn't intend to do that. You were in a fight. You can't legislate a fight. A fight with a human being that may have a knife or a gun or maybe bigger and stronger than you is life and death. And so I appreciate the remarks of my friends that, we have a high standard that we have to apply to our law enforcement officers. We have to apply to them. But at the end of the day, they are still simply human beings. And you can't apply standards to them which are unfair. And I think that the language I've suggested keeps the requirement that law enforcement officers do everything they reasonably can to use less lethal means to control the situation before they resort to lethal force. It says that. I would never try to eliminate that. But all and exhausted is going to lead to, I think, a lot of repercussions. I press the amendment, Madam Speaker.
Question before the House is the adoption of the amendment. All in favor signify by saying aye.
Aye.
Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. The gentlelady from Hartford in the annex.
Thank you, Madam Chair. I have an amendment at the desk, amendment number 543920-1.
Amendment number 1.
Move so much to consider of reading the amendment.
So ordered.
I too have my amendment under the use and force portion of this particular legislation. Under this bill, a police officer shall intervene if another officer is violating sections 2 and 3. In this, you are actually expecting all officers involved to have equal knowledge of the details leading up to the arresting officer's use of force, when most of that evidence occurred prior to their arrival on the scene. Then you are holding that officer responsible to decide to intervene in a split second to stop the arresting officer from using force in extreme volatile circumstances, putting him and the entire police force and the arresting persons at harm. Police work is dangerous. It's unforgiving. It does not have the advantage of following a script. Every situation is different and generally unknown. As a spouse of a retired police officer for 24 years and a mother-in-law of a current law enforcement officer, I stand in confidence to say that this bill needs more consideration in order to create fairness across the board. This bill is not ready for prime time. This bill will negatively affect the safety of those they serve and the policing as a whole in our entire state. The amendment simply adds on page 17, line 16, before the word intervene, when time, circumstances, and safety allows. Madam Speaker, I press the amendment.
Madam Speaker.
Vice Chair of the committee.
Thank you. I would urge the body to reject this amendment, and I am going to toss this over to my colleague from Charles County.
Gentleman from Charles.
Thank you, Madam Speaker. I'm joining rejecting this amendment. The language is very clear, and the issue we have a lot of times in dealing with law enforcement is omission and commission are the same thing. We're not saying that when you run up on a scene and you see somebody that is face down with a police officer on top of them that you have to pull that officer off. It says you intervene and terminate the use of force by another officer, as this paragraph states. So the amendment she's asking is already in the language. It allows you to use your situational awareness to come upon a situation because it is the force that is necessary and reasonable under the circumstances. And as everything, it's the totality of circumstances that matter. So of course, if you jump out of a car and you see an individual and the police has a gun drawn on him, there's nobody expecting you to slap the gun out of that police officer's hand because you don't know if he just robbed somebody or if it's a traffic stop. Of course, again, I keep forgetting, we keep equating that these aren't trained individuals, that they don't understand situational awareness, that they don't have the head on a swivel, that they don't know how to check their corners, that they're just like each of us. But that's just not the case. They're responding to an incident. Communication is sacrosanct in any of these operations, and they're doing that. I don't want you to react as I would react. I want you to react as a trained police officer would react. And that trained police officer would look around, pay attention to the set of circumstances, communicate with the individual who has the gun, who has the individual in a leg lock, prior to intervening. This bill doesn't ask you to perform miracles. It doesn't ask you to read minds. It asks you to be a well-trained professional in dealing with your law enforcement responsibilities. I ask you to reject this amendment because it's unnecessary. The bill gives them the latitude to be police officers. It's what's reasonable. It's what's proportional. I hope that they're trained enough to make that decision. But I want to make it very clear that omission and commission are the same thing. I expect our law enforcement officers to be held accountable if they watch somebody violate the law, because they would hold me accountable if they watched me violate the law. That's a minimum standard. If they watch somebody violate somebody's constitutional rights, I want them held accountable, because they should know that individual's constitutional rights better than he or she does. This bill is asking us to treat these individuals like the professionals that they are and raise them to a standard that I know that they can meet. Allow them to be responsible for their actions and be observant and responsible for the actions that they allow to happen around them. So for all those reasons, I ask that you reject this amendment.
The gentleman from Baltimore and Harford counties in the annex.
Thank you, Madam Speaker. And to speak on this amendment and support the amendment, I wish that it was just as easy as it was just said. But it's not that easy. And it's not easy in a split second. It's not easy over a long period of time. I recall it wasn't that long ago that an African-American officer was gunned down by his own fellow police officers because he wasn't in uniform, because he drove onto the scene in his unmarked car and he has attempted to aid the other officers, but in that split second, they mistaken him as another culprit, not because of his color, but because they were all uniformed officers at that position and he didn't announce himself properly. So should they be charged for that? And when two officers standing with each other, side by side, and all of a sudden, that one officer, for no reason, it seems whatsoever, jumps on that person that they're dealing with and throws him to the ground. Is that other officer supposed to jump in right then and pull him off? Because that officer doesn't know. Did he see a knife? Did he see a gun? Did he see something that would endanger both of their lives? And when that officer pulls up on that site and those two are rolling around on the ground, does he know whether there's a gun underneath that they're fighting for? He doesn't know. So putting this type of legislation in and not giving law enforcement the proper protection really goes down to that simple fact. Do we want to be judged by 12 or do we want to be carried by 6? I've heard a lot about color, but most of these police officers that are killed in the line of duty are killed for one simple reason: because of their color, because they're blue, because they're wearing blue. This doesn't protect police officers. A police officer shouldn't be put in a position where he's got to make a split-second decision on, should I jump in and stop when I don't know all the facts? They need to stay back. They need to weigh the facts. And they need to participate in the way they're trained to. And then when it's all over with, they have to figure out what happened. We need to give them that benefit of the doubt. We need to make sure that they feel safe every day going to work, that they don't have to second guess every single decision they make, because when they second guess the wrong decision, they're not coming home to their family. They'll be carried home by their family. They'll be carried home by 6 of their brothers. And for that reason, I support this amendment and ask that you vote green on this amendment. Thank you.
Gentleman from Charles.
Thank you, colleagues. Again, just a few brief comments. The way they should be trained and the way they've been trained is you yell knife, you yell gun. They're trained for this. What's terrifying is the standard we keep talking about of a simple man that just happens to have a badge and a gun. Let me tell you, this bill requires more training than our police officers currently have. It requires a lot more discipline and knowledge of the Constitution, their rights, and mine. I want them to be trained, because you know what I'm terrified of? Because I'm a chunky 240 right now. I'm terrified of a scared police officer. I'm terrified of a shaking gun, because they don't have the confidence, because they have not been properly trained and they see me as a threat, because I want to go home too. It is important that we understand that we're talking about the use of lethal force. We can have some standards on this one, man. It boggles the mind. I'm all about law and order. I understand when crime goes up, minorities suffer more than anybody. My community suffers. My schools suffer. My property loses value. I will never talk bad about law and order. But I want them to be trained. I want them to know how to deal with people. I don't want them to be scared of me because they've misjudged me, because they're just regular Joes that got out of bed today and put a badge and a gun on. That is unacceptable. We expect more. If they don't know to yell that there's a gun when they see one, Christ, they shouldn't be carrying one. We have got to understand these aren't regular individuals who just happen to fall upon a badge and a gun. We have empowered them with almost every right imaginable, and to take away every one of mine with just their word. How dare we keep a low standard? We've seen what happened, and what this bill is trying to do, this mask is driving me crazy. What this bill is trying to do, it's trying to repair a rift between my people and law and order, and law enforcement, excuse me. It's trying to make sure that we have the trust and the faith that they're trained to not see us as an enemy, that they know they're not just here to protect. I don't need another gang on my street. They're here to serve me. My name is Sir. I am Mr. Wilson. You don't need to draw a gun if I got a suit on or if I got a tank top on. Just because you see my tattoos, that doesn't make me a threat. Even if you just arrested a guy with tattoos. I deserve that dignity. That's what this bill is trying to do. We don't want to weaken it with this amendment. We want our law enforcement to be trained. I want to accept their power and authority over me, and I want them to deserve it. This bill will make sure that we bridge that gap. Please reject this amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. Gentlelady from Prince George's in the annex. Disregard. The gentleman from Calvert and St. Mary's.
Well, I'm sure everybody's thinking, wow, they even got Jerry getting up and talking tonight. Excuse me for using my name. We're going to move on a little bit from use of force to qualifications and training. I'm very pleased to hear the committee chair and the floor folks, leaders, talk about what the police should know and what they should do. My amendment, and I have an amendment at the desk, and it's amendment number 173-820/1.
Amendment number 1.
So be the reading of the amendment.
So ordered.
Okay. What this amendment does is speaks to a few of the things that the good delegate from Charles County has been mentioning in a lot of his speeches this evening. What this does is this develops the training for police officers to include the United States Constitution and the Bill of Rights. It will require these officers, all new officers, to complete the training, and would require the incumbent officers to undergo the training developed on an annual basis. I think this is a pretty simple amendment, It doesn't speak to anything but training and folks knowing what people's rights are, and it's something that should be pretty easy for everybody to support, because no matter what, no matter how much we argue here tonight and go back and forth, we're all Americans, and we all live by the Constitution and the Bill of Rights. Thank you, Madam Chair.
Floor leader.
Thank you, Madam Speaker. Colleagues, this is a well-intentioned amendment, but I actually don't think it's necessary. There's actually existing law that designates the Police Standards and Training Commission's duties, and in their existing trainings include topics such as federal and state constitutional provisions, evidentiary procedures, criminal law. So this is more or less already covered. A lot of the things that are put into this provision of law are also things where we'd like the police to take a special effort to look at something they might not have already covered, and this sort of aspect of law in the Constitution is actually a part of their everyday training. So again, I think it's well-intentioned, but probably unnecessary. Thank you, Madam Speaker.
Maker of the amendment.
The floor leader, well, you know, it could be that it is something that's in their other training, but isn't it something that they should do on a yearly basis? And what harm would it do for all new policemen to take that training, and for all incumbent policemen to take it year in and year out? We're here tonight to try to improve policing and do what's right for the people of the state of Maryland. And if having to go take a class, just like we have to take a class every 2 years on harassment, what is wrong with that? I don't see why there's anything wrong. I think this would lighten your bill a little bit, make it more flavorable out there for the people, all the people of the state of Maryland, to show that we really believe in the Bill of Rights and the Constitution of the United States. I'll press the amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Oh, clerk, call the roll.
Madam Speaker?
Clerk will take the call. The amendment fails. The gentleman from Anne Arundel in the annex.
Thank you, Madam Speaker. Would the floor leader rise for a question, please?
Good evening.
Chairman of the committee.
Good evening.
Good evening. How are you tonight?
Great. Nowhere else I'd rather be.
Excellent. Just have a couple questions on this section of the amendment where the police supervisor must respond to a scene. Can you define physical force and physical injury?
Physical injury would be any physical injury. Physical force would be any physical force. There is a distinction in the law that I think you're going to be raising here in a moment in the criminal law article that talks about serious physical injury, which usually results in some kind of disfigurement or something more substantial. Lethal force is defined in the bill.
Right, lethal force, but not physical injury or physical force.
No, you would take those at their regular definitions. If they were brought up in court, you'd take physical force and physical injury. You'd have to demonstrate that somebody was injured.
Right. So they're not defined. Now, does this include all type of arrests? Most of arrests require some sort of physical force. Would that be included in that?
If they were injured, then you would have a supervisor. You'd have a supervisor arrive. Yes, as the bill is written.
So someone is getting arrested and they get scratched or bruised, that's considered physical force?
It would be, if they were scratched or they were bruised, that could be considered to be a physical injury.
What if someone claims that they have physical injury, but there's no evidence?
If there's no evidence of a physical injury, then there's no evidence of a physical injury. Then it's not
But they
physical
claim
injury.
that there's a physical injury. Would the supervisor have to come to the scene?
They'd have to demonstrate that there was a physical injury. If they can't demonstrate that there's a physical injury, then the supervisor wouldn't need to attend. This would be a responsibility of the police officer. If the person was injured, if they knew they were injured, they would need to make sure that their supervisor was there.
How often do you estimate a supervisor is called to scenes, for example, in Baltimore City?
I honestly don't know how many times a supervisor was called in Baltimore City.
Thank you. Thank you, sir. I appreciate it. Madam Speaker, I have an amendment at the desk. Amendment number 923327-1.
Amendment number 1.
So much should be considered reading the amendment.
So ordered.
Thank you. I'm not sure if this was an oversight, but in section 3-201, lethal force is referenced multiple times, but it's not mentioned in this one. What this amendment would do was actually strike physical force and will substitute lethal force and physical injury and will substitute with serious physical injury. This way, it's consistent with the remaining of the references to physical injury in reference to, as defined in 3-201 of the criminal law article. It's just a simple common sense amendment, just makes it consistent with the rest of the bill or the amendment. I move the amendment.
Committee Chair.
Madam Speaker, the committee considered this language, and I think they considered it in a light that seeks to provide at least some degree of follow-up for the police officer themselves. That if someone is claiming that they were physically injured, that there would be a supervisor there who could say, okay, what happened in this case, and make sure that everything was being done right. So there's sort of deliberately a lower standard there, and that's why we have it in the bill. So, Madam Speaker, that's our rationale for having it in the bill.
But in the bill, the lethal force was referenced multiple times, but not in this particular section. So was that maybe an oversight? And that's what the reason of the amendment.
Well, just because it's not mentioned there, I mean, again, I think that there is an argument that says that you want to have a bit of a broader definition there, not only for the protection of the person who was injured, but also for the police officer who may be accused of being injured down the line. So just because we have lethal force in other parts of the statute, it doesn't necessarily mean that we have to use lethal force in every single part of the statute. So that's at least the rationale for this part of the...
Right, but we define it everywhere else in the statute, but we don't define it here. So why not define it here so it just makes it black and white instead of leaving it to a gray area?
I don't think we need to here, but I understand you're going to press the amendment.
Thank you. I press the amendment, Madam Speaker.
Okay. On the amendment, all in favor signify by saying aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. The gentlelady from Carroll in the annex.
Thank you, Madam Speaker. On this bill, I have an amendment at the desk. Amendment number 393-422-1.
Amendment number 1.
Thank you, Madam Speaker. This amendment is very simple. This is restricting prior marijuana use to the current federal guidelines, on who is prohibited from owning and purchasing a firearm. Obviously, our law enforcement must be able to have a gun in their possession to do their job. Are we going to allow prohibited persons to waste our officers' time and resources to come in for interviews if ultimately they're not able to have a firearm? When will they get cut? After we spent how much money processing them? I have a background in recruiting, and I can tell you for sure the recruitment process and hiring process is costly and lengthy. And as we all know, our dollars are very precious. According to the NICS form, it asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? In addition, it issues the warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state in which you reside. That means any use. So again, this is going to be very costly. I spoke with my sheriff about this today, and I asked him, can you walk me through the process? How does this work? What is your recruitment process, and what are the costs? He told me it's a multi-level process. They have someone that does background checks, 4 contracting folks that do that for us in Carroll County. That process alone costs between $800 and $1,000. To do the polygraph, which takes 4 to 6 hours for the applicant, costs about $1,000. To get the psych examination, $1,000. All in all, the process in total, according to my law enforcement in my county, costs between $10,000 to $15,000 to process these applicants. How can you not look at this and realize that this is not the way to go about this process, and this amendment will prevent wasting thousands and thousands of dollars and countless hours, not only for the law enforcement agency, but also for the applicant. In addition, my sheriff wanted to make one additional comment that I think is very important. The entire process of this bill isn't one of the things that we want is to hire policemen, policewomen, good cops with clear minds? I would think so. If we want them to make good decisions on things that we've talked about all evening, use of force, doing things in the right way, don't we want them to do that with a clear mind, to make good decisions and not under using mind-altering drugs? So for that reason, Madam Chair, I press this amendment, please.
Floor Leader.
Thank you, Madam Speaker. Colleagues, I urge you to reject this amendment. Look, the question posed here is not something unique. I'll just tell you the story in Topeka, Kansas, that I was just reading about, where in neighboring Colorado, marijuana was legalized, and so they were confronted with a policy question about whether police officers or those who sought to be police officers in Topeka should be prohibited from joining on the basis of having previously smoked marijuana. And what they discovered was their policy made it so that a young person, perhaps who went legally to Colorado to smoke marijuana legally in that neighboring state and later applied to be an officer, might be prohibited from the one time legally smoking marijuana in that state. But someone, say 3 years ago, who was a habitual marijuana user might have been allowed under their rules because it had asked them, had you done it in the last 3 years? And so the conclusion they came to was they needed to think about what was the purpose of these rules in the first place. Is it to stop people who are currently habitual smokers? Is it to stop someone who did just have that one time that might have been legal? And I will tell you, that's what's happening to us right now. DC, Virginia, New Jersey, the neighboring states have legalized, and so this is not a hypothetical question. This is a real question. Do we actually allow people who want to be police officers to partake in what is legal in now 3 neighboring states for us? And so the decision of this committee was to say we are not going to automatically bar someone on the basis that they previously smoked marijuana from being a police officer in the state. They might not get the job for other reasons, but we're not going to immediately say, you answered this question honestly, you can't be a police officer. And the reason for this should be obvious. We want police to reflect the communities. You probably saw the polling that that just came out through Goucher. 2/3 of the state supports legalization. At least half the state, last check I saw, admitted to having tried this at some point in their life. And the most important factoid, from Montgomery County to the shore to Baltimore, is that for years, thousands of our residents have been getting criminal charges, disproportionately people of color, despite equal use. So yes, we've got to remove this. This was requested specifically by folks in Prince George's that are having actual recruitment problems with this. So again, we might not agree on this, but I don't think this is a good amendment, and I would ask you to reject it.
On the amendment.
On the amendment.
Thank you, Madam Speaker, and I appreciate the comments from my colleague. However, I don't believe we make policy in the state of Maryland based on what Colorado does, the District of Columbia does, or Virginia does. I think we should be making policy based on the state that we live in, which is Maryland. We do not have legalized marijuana at this time, as everyone is well aware. We also don't make policy based on polling numbers, to my knowledge. So again, if the purpose of this entire bill, this amendment aside, is to hire good people to serve in law enforcement and to be operating with clear minds to make good decisions for our citizens, I think this amendment is extremely important, and I ask for the amendment. I press for that tonight. Thank you.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails.
Madam Speaker.
Recognizing the minority whip.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment 463623/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. I have a couple questions for the floor leader leading up to my amendment. Hi,
Vice
over
Chair.
there in the plastic box over there. My amendment deals with the Police Training and Standards Commission, and that can be found in the section 3-113. I think it's page 15. So I can see that the committee's made a number of changes to this Police Standards Training Commission. It looks like on line 8, if your bill and my bill line up, you're striking the chair of the Maryland Municipal League Police Executive Association and the president of the Maryland Law Enforcement Officers.
Is that a question? I'm sorry.
Yes, it
Okay.
looks like you're striking them.
Yes.
And then you're also removing the president of the Police Chiefs Association of Prince George's County, the Warwick Program Advisory Committee for Criminal Justice, and then 2 members of the Senate and 2 members of the House.
Correct.
Can you let us know why the committee decided to do that?
Yes. So I'll start with the 2 members of the Senate and the 2 members of the House were struck because before the Maryland Police Training Standards Commission, and I know we're not supposed to talk with acronyms, but I'm going to say MPTSC. I said it right the first time, so is now more than just a policy making entity, and so we can't serve. They are actually serving as an accountability oversight for the police, and so that's why we had to be removed. The others that you mentioned were removed because we added 9 citizens to the commission that do not have a relationship to law enforcement, and we add an individual with expertise in mental health that does not have a relationship with law enforcement, all so that there can be more citizen participation in the process. But I will point out that the Commission retains the president of the Maryland Chiefs of Police Association, the president of the Maryland Sheriff's Association, the Attorney General, the Secretary of the State Police, the agent in charge of the Baltimore office of the FBI, and a member representing the FOP, and a member representing the Maryland State's Attorneys Association. So it was top heavy. The work group thought, this was done in the work group and the Judiciary Committee retained it, thought it was top heavy with law enforcement and not enough citizen participation.
Because, yeah, I noticed on the next page you also removed 3 police officers from different geographic areas and an individual with expertise in police standards. So you're removing police, you're putting on 9 citizens of the state without relationship to law enforcement. So my amendment deals with that exact language, without relationship to law enforcement. And I'll start with the individual with expertise in mental health. And you added to that person, they have to be without a relationship to law enforcement. I would say that the person with mental health expertise should actually understand the psychology of law enforcement. But in House Bill 4, you went and defined relationships, but without relationships to law enforcement seems quite ambiguous. I mean, this is the law, and I think you just told us words have meaning. So what does that mean? So my neighbor's a retired cop. I see him like every week when we take our trash out. He's a great guy. You know, I think of John Cluster that many of us knew, Michael Jackson, Senator Michael Jackson, he's law enforcement. What is that term without relationship to law enforcement? What do you mean by that?
It means that the individual can't work for law enforcement currently.
So relationship, what if I dated somebody in law enforcement? Would that be a relationship?
No, we're talking employment.
Employment. So perhaps you need an amendment to clarify employment relationship, because relationship is a much broader thing than employment. And in House Bill 4, you know, the committee did a job, immediate family member, spouse, parent, step-parent. You went on a full list of people, but without relationship to law enforcement is ambiguous, and I'm surprised that you did not define that further. So I will speak on my amendment. Thank you, Floor Leader, for answering those questions. This amendment is 2 parts. First of all, it removes the language without relationship to law enforcement on the person with expertise in mental health. And we would want that person with expertise in mental health to really understand the psychology of being a law enforcement officer. These are men and women that see things that civilians don't see. If any of you have not taken the opportunity to do the virtual policing opportunity with the police academies that I did with my friend from Towson, my other friend from Baltimore County, it's a phenomenal experience to see what it's like in a virtual setting to, for a moment, make decisions that police officers make. And I think it's important that that person have a relationship to law enforcement and understand them. And then secondly, the amendment removes the language of the 9 citizens of the state without relationship to law enforcement. Those citizen members of this Police Training and Standards Commission, why wouldn't we want some? I'm not saying all 9 of them, but to directly preclude someone from serving that understands firsthand. And I would contest that relationship is family, familial, more than a job, a wife, a husband, a child, someone who really understands the challenges of being in law enforcement. We would want them to bring that perspective to the table. So I urge the body to accept this amendment and clarify that this is okay. It's good for people serving on this important commission to really understand law enforcement, and I press my amendment. Thank you.
Vice Chair of the committee.
Thank you, Madam Speaker. I would urge the body to resist this amendment. The work group and the committee thought it was important that there be a balanced and unbiased view of the Maryland Police Training and Standards Commission. And so that was accomplished by having half of the members have a direct connection with law enforcement, and the other half of the members be citizens. I also would like to point out that all of the members of the commission have to undergo training. And so they will become familiar with law enforcement in that sense. And I think most of the members of this body know that we actually do have a problem, and we've had legislation in front of our committee with police responding to individuals who are going through a mental health crisis. So I think it is important that we have mental health experts who aren't related or who do not have a relationship with the police. And with that, I would urge the body to resist this amendment. Thank you, Madam Speaker.
Madam Speaker.
Maker of the amendment.
Thank you so much. I thank you for your explanation, Floor Leader, but I urge we pass this. I think it's important that we allow people with a relationship to law enforcement to serve. And secondly, if you reject this amendment, I urge you to fix this language. This just isn't our best work product when we say without relationships to law enforcement, without actually defining what those relationships mean. So if you pass my amendment, you fix it right away.
On the amendment, all in favor signify by saying aye. Opposed?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. The gentleman from Carroll in the annex.
Thank you, Madam Speaker. I have an amendment at the desk. It is Amendment 213825/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. This amendment pertains to access to records, but it really pertains to fair access to records. And specifically, with regard to page 30 of the bill, the language of the amendment would provide that a record relating to an administrative or criminal investigation of misconduct by a police officer is a personnel record. Parenthetically, because personnel records get treated differently than disciplinary records under this particular bill. So that would only kick in, however, if the result of the investigation found that the officer did not commit the alleged actions. So down here, over the last 7 years or so, I've seen us pass a plethora of bills providing folks with additional chances. And we've made it easier to shield records and expunge records. I do a fair amount of criminal work, and I can tell you in criminal law, if you are acquitted, you can get the record of the offense for which you were acquitted expunged immediately, and rightly so, and it doesn't cost you a nickel, and rightly so. But shouldn't we give that same modicum of protection to police officers when an investigation reveals a complaint to be unfounded? And with that, Madam Speaker, I'd move the amendment.
Committee Chair.
Thank you, Madam Speaker. I'd ask the body to resist the amendment. The process by which police records are to be addressed in the bill, it is something that will provide more information, more important information on every side of the police investigatory process and in the police misconduct process. We have challenges in our system right now where people have significant questions about whether police misconduct and police misconduct is being properly investigated, is being sincerely investigated, and is being investigated in a way that supports people who have been the victim of police misconduct. And so to that end, the committee felt that it was important to have not only sustained complaints, but also unsustained complaints, or complaints that were not administratively charged, available as public record. Still, what happens here is those records have to be requested through the Public Information Act process. The custodian can deny, and this is existing law, the custodian can deny inspection by a person in interest to the extent that it would interfere with a valid law enforcement proceeding, deprive another person of a right to a fair trial, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose an investigative technique or procedure, prejudice an investigation, or endanger the life or physical safety of an individual. So there are some safeguards there to make sure that none of those things happen. Furthermore, there are further abilities for a custodian to be able to say that if somebody is being vexatious, and I feel like we're going to talk about that again here in a moment, if people are deliberately seeking to gum up the process, that they can deny access to those records as well. So in the end, the committee felt that it was important that these records be available to the public so that people can see the complaints that are coming in, and so that they can see that the investigations are being done properly and that the complaints are being addressed properly. And all of that, in the end, helps build better confidence for our police departments.
Madam Speaker, the only response I would make, Madam Speaker, with regard to the use of the word vexatious is that I think that's an awesome word, I got to tell you. It's one of those 25-cent words, but in 28 years of practicing law, I've never had occasion to use it until tonight. So it's a great word, and kudos for you all for coming up with that word. But with respect to the amendment, keep in mind that we're only treating this as a personnel record if the result of the investigation found that the officer, and the investigation could be either an administrative investigation or a criminal investigation. If the result of the investigation found that the officer did not commit the alleged action, we should give those folks the same protections that we're affording people charged under criminal statutes in other areas of the law, particularly with respect to actions that we've taken down here as a legislative body over the 7 years I've been here. So I press the amendment, Madam Speaker.
On the amendment, all in favor signify by saying aye. Oppose, no.
Roll call, Madam Speaker.
Roll call.
Madam Speaker? Oh, I don't know.
I can't.
I don't know what happened.
Can you clear it? Clear it, and clerk will call the roll.
Madam Speaker?
Clerk will take the call. The amendment fails. Gentleman from St. Mary's.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment 503524/1.
Amendment number 1.
So this is almost somewhat of a technical amendment, but on page 24 of the reprint deals with the administrative charging committee, and it has resident of the county as one of the members of the charging committee. And to me, that seems a bit broad. So what this amendment does is define that resident as a citizen of this country, and also a citizen that has not been convicted or charged with a crime that is subject to imprisonment of more than 90 days. Makes logical and reasonable sense to me that if we're going to have people judging police officers for wrongdoings, that they should be citizens of this country and not be past criminals. So with that, Madam Speaker, I move the amendment.
Recognizing the committee chair.
Thank you, Madam Speaker. I'd ask the body to resist the amendment in large measure because it says that all it takes is a criminal charge. All it takes is a criminal charge. And I would say that includes, if I'm reading this amendment correctly, anything that is subject to imprisonment for more than 90 days, that would be a DUI. That could be that. Let's see. 7 years ago, you were charged with a small amount of marijuana. That could be that when you were young, you shoplifted something from a store. So there's nothing that says it could be a bar fight. That could be any number of different things. And quite frankly, I think the amendment is. If the concern that the bill is overbroad, the amendment is extremely overbroad, and I'd ask the body to oppose it.
Madam Speaker.
Gentleman from Baltimore County.
Just briefly, I support the amendment. I think this board should be made up of course, legal citizens. I mean, somebody here unlawfully certainly should not be judging somebody whether or not they broke the law, and it's unfair, I think, to place the police in a situation to be reviewed by a person who's had a recent negative encounter, for example, and I think this board should consist of unbiased people who can objectively review the facts, and I have pushed the amendment. Thank you.
On the amendment, all in favor signify by saying aye.
Aye.
Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk would take the call. The amendment fails.
Madam Speaker.
Recognizing the gentlelady from Carroll.
Thank you. I have a question for the floor leader.
Madam Speaker.
Oh, hi over there.
Floor leader.
Thank you, Madam Speaker.
Thank you. I just had some questions about this independent investigative agency. Can you explain to me how we investigate crimes or alleged allegations against police officers today, and then how this new independent investigative agency will work?
So currently, when there is a complaint made by a citizen, we do not have a uniform way of doing that across the state. So each agency, so I can't tell you because each agency does it differently, and they use their own police force to do it. And so what the work group and what the Judiciary Committee wanted to do was to have an independent look at that. We didn't want the police necessarily policing themselves. So this creates an independent agency that would investigate a complaint of police misconduct.
Is it just any kind of complaint, or is it specific kinds of complaints?
I'm sorry, can you just put your mic a little bit closer? I'm having a little hard time hearing.
Sorry, having this mask problem. The way I read it, it's certain things that this independent investigative agency is going to look into. Can you tell us what that is?
Yes. So the independent investigative agency will look into incidents that result in death or serious bodily injury.
Because just a minute ago you talked about a civilian complaint. I mean, we're talking about serious business here. We're talking about investigating use of force incidents involving police officers. And you said currently, I just know in our county currently, if we had that situation, we're a medium, small county, we would call the state police. So we, because we're not big enough to do that. I would assume that the bigger counties have their own processes in place to take care of something for these very specific things. The purpose of investigating use of force incidents involving police officers. Is that correct?
So what I will say is you're correct. Your county might call the state police, but that might not be what Montgomery County does, or Howard County, or Baltimore City.
Okay, I understand. But a minute ago you just talked about a citizen complaint. This is not about citizens' complaint. This is about these very, very specific incidents that are very serious. And basically this independent investigative agency, it says it may employ sworn police officers and civilians to conduct its work. So who is it that decides who's going to be on this new independent investigative agency? Who chooses
Well,
it?
in the legislation, we have not. It's not housed currently.
Well, it's only like 2 paragraphs long. It doesn't tell where it's housed. It doesn't say how they get appointed, who they're accountable to, who they are. So what do you see? It's not written in here, and it doesn't really tell you very much. It's just this new independent agency. So who will appoint them? Who are they accountable to? Are they elected? What's their background?
Well, it's not. It doesn't specifically say it in the legislation currently.
So when will that be decided, and who will decide it?
Well, that will be decided, I imagine, quite frankly, in conference committee.
Okay, so we have a bill in front of us that's putting a new independent investigative agency in place for the purpose of investigation use of force incidents involving police officers. And this independent investigative agency may employ sworn police officers, and they shall, the governor shall annually include funding in the state budget sufficient to provide for the full and proper operation of this new investigative agency. But we don't know who's going to appoint them, what they're going to do, where they're going to be housed. Are they going to be paid?
So what the work group, the intent of the work group and the intent of the Judiciary Committee is to not have the police themselves. And I do want to make one correction. You said this involves, use of force, death, and serious bodily injury, which is correct, but that could be a citizen complaint. I think you mentioned that's not a citizen complaint. A citizen could file a complaint saying that an officer used excessive force on me. So that certainly could be a citizen complaint. And so what we know, what we found out through the work group, through the testimony, and the different folks who came in, national experts, local experts, that there have been no individuals convicted of use of force incidents in the state of Maryland. Convicted. That different than charged, but convicted. And so what the work group thought was best is that you don't have the police, some folks that you work with side by side every day who have a relationship, having to investigate themselves. You need someone, an independent look at it. And so that's where we're going with this.
And I would just like to mention, I do have an amendment, but this whole section is problematic. It probably needs like a ton of amendments. We're basically putting forth an independent investigative agency. We don't know who's going to appoint it, what their job's going to be, are they going to be paid, where they're going to come from, who they're accountable to, and we're going to decide this in a conference committee. It doesn't sound like good policy to me at all. The governor shall annually provide funding in the state budget sufficient to provide for the full and proper operation of this independent investigative agency. So a little food for thought. This independent agency shall publicize whatever report they put out after the state's attorney makes a decision whether or not to prosecute. So there again, whatever they find out is shall publicize the report. So it sounds very open-ended to me. But one of the things that I have an amendment at the desk. It's amendment number 533723/1.
Amendment number 1.
So be reading the reading of the amendment.
So
this
ordered.
Amendment, excuse me?
I'm responding, so ordered.
Find it.
Deal with your amendment, please.
Thank you. This amendment basically just says that this, instead of saying the independent investigative agency may employ sworn officers and civilians to conduct its work, it basically says it shall employ sworn officers to conduct investigations. And the reason I push this, I think it's problematic to not have, first of all, I don't even think we need a state independent agency. I think we have plenty of, the state police is already intended for that purpose. But further establishing an independent agency at this level with no police officers on it, what other board or commission do we have in the state of Maryland that does not police their own? Whether it's a health board or whether it's whatever it is, there are people that with knowledge of what's going on. If it's a doctor, there's doctors on the board. If it's nurses, there's nurses on the board. If it's an electrician, there's electricians on the board because they know what's supposed to go on. So the fact that you could have a board to police officers or investigate police officers that could have no law enforcement on it is problematic. So I basically ask you all to just accept this amendment to say that they shall employ sworn police officers to conduct investigations, and I move the amendment.
Vice Chair of the committee.
Thank you, Madam Speaker. I thank the delegate for providing this amendment ahead of time, but we would ask the body to reject this amendment. First of all, if we say shall require sworn police officers, that would preclude retired homicide cops, retired police officers, retired detectives from serving, retired FBI agents or what have you from serving in the investigative capacity. And also, I would just like to point out that they don't need to be sworn officers because it's an investigative agency. They're not arresting. They don't have arrest powers, so they don't need to be sworn. And for those reasons, we would ask the body to resist this amendment.
Thank you, Madam
Maker
Chair.
of the amendment.
Thank you. I'm just going to encourage the body to support this amendment. We cannot have people like myself. I know nothing about law enforcement and what goes on in law enforcement. There should be someone on that investigative board that has been a sworn police officer to conduct these investigations. That's the way it's done now. We use the state police. I don't know what your county uses. I know many of our counties, the smaller counties, do use the state police. It's worked very well. I always ask, what's the problem that we're trying to solve? I don't see a problem that we're trying to solve because we have people in place now to do these investigations. So I'm going to push the amendment. Thank you.
On the amendment, all in favor signify by saying aye. Opposed? No.
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails.
Madam Speaker.
Recognizing young lady from Carroll.
I have another amendment at the desk. Amendment number 703-529/1.
Amendment number 1.
So be considered the reading of the amendment.
So ordered.
I just happened to be looking through the testimony, and I noticed some testimony from Mako and from Baltimore City Police. And this this particular amendment has to do with any city under a federal consent decree is exempt from any portions of this legislation which may contradict the instruction of a federal consent decree. How did I come up with that? Well, by reading the testimony from Mako and from Baltimore City, they have concerns that the circumstances of the Baltimore City Police Department currently operating under a federal consent decree merits appropriate deference. Rather than rehash these issues in detail here, our associations echo the perspectives of Baltimore City government and Baltimore City Police Department. That's from Mako. Basically, Baltimore City Police Department in their testimony said, we do not support this proposal of the independent, we fear that the creation of the IIA would limit our ability to comply with the consent decree and that the IIA would be subject to the mandates of the consent decree. Therefore, we respectfully request that page 15, blah, 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 blah. That's what this amendment does. So we're concerned about the Baltimore City consent decree, and it basically will make sure that we are following all of the guidelines in the federal consent decree for Baltimore City. I move the amendment.
Recognizing the committee chair.
Thank you, Madam Speaker. Ladies and gentlemen of the House, I ask you to oppose and vote against this amendment. The consent decree for Baltimore City is something that I think is important, very important. The people of the city of Baltimore, to policing in the city of Baltimore. As a resident of the city of Baltimore, I do not want to do anything that would stand in the way of the Baltimore Police Department being reformed, the Baltimore Police Department doing what needs to be done to engage in proper policing, constitutional policing for the people of the city of Baltimore. As chair of this committee, we're not going to put forward anything that's going to stand in the way of the consent decree doing what it needs to do. Under the consent decree, and I'm going to just read from the consent decree's website, in baltimorecity.gov. Under the consent decree, the City of Baltimore and the Baltimore Police Department will work with communities to implement comprehensive reforms that will ensure, relevant to this, allegations of employee misconduct are fully, fairly, and efficiently investigated, that all investigative findings are supported by the appropriate standard of proof, documented in writing, and that all officers who commit misconduct are held accountable pursuant to a disciplinary system that is fair, consistent, and provides due process. For the last 9 months, my committee, the Speaker's work group, have done nothing but work to make sure that we create that process not only in the city of Baltimore, but statewide. I'm proud of what we've done. I'm proud of what we're going to see in this police misconduct system, and it will not violate the consent decree. It will only enhance it. Thank you, Madam Speaker.
Madam Speaker.
Maker of the amendment.
Thank you. I'm just reading from the Baltimore City Police Department's testimony. We do not support this proposal for a variety of reasons, the most important of which is that our federal consent decree mandates that we establish and maintain a serious incident response team which is composed of sworn officers. And you just voted that amendment down that we offered before. They must be composed of sworn officers who have received special training to investigate the incidents described in this section of the law. Our federal consent decree monitoring team and the Department of Justice both are immediately notified of incidents in this category and receive on-site briefings and the 24-hour briefings. They're responsible for evaluating how we handle the matter. I move my amendment.
On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails.
Madam Speaker.
Recognizing the minority leader.
Thank you, Madam Speaker, and good evening. I have an amendment at the desk. It's amendment number 353126/1.
Amendment number 1.
You'll be happy to know that I think this may be the last amendment for the day. You could be a little bit more excited about that. I'm not going to suggest, I'm going to be modest, I'm not going to suggest that it's the best amendment, but I think it's pretty good. I want you to think about the gun trace task force and all the corruption that existed with that. Fortunately, some other cops turned in those folks. But I want to point out this amendment before you will do something that I think is very important. Currently, the bill before us is silent as it relates to complaints alleged from an officer regarding another officer. And what I fear is we might miss a valuable opportunity to add a part of the reform that I agree with to this area. So outside complaints go before this independent group, but internal complaints could be dealt with exclusively by a chief or a sheriff who may want to cover up corruption by getting rid of somebody that they think is a problem. The system before us has some good things in it, the system that's being advanced. I'm not opposed to all of it. One of the things is having an independent group look at this stuff, look at the complaints. But I think that, it kind of leaves a loophole here for internal complaints to be dealt with. I mean, let's face it, some chiefs are great, some sheriffs are great, but not always. There's no doubt that they're political. It's unavoidable. And I'd certainly hate to see we not add the same protections for internal complaints as we're providing for external complaints. So with that, Madam Speaker, I want to urge the body to adopt this amendment. Thank you.
Committee Chair.
Thank you, Madam Speaker. Respectfully, the committee would ask for the body to resist the amendment. This is an issue that we certainly have been discussing a great deal in the committee. It's an issue where I think we want to maybe look at this amendment a little bit more than what we're going to be able to do tonight. And certainly we think that there are ways that we could make this amendment, I think, even a little better and address the gentleman from Anne Arundel, the minority leader's concerns. But for tonight, we'd ask you to resist the amendment.
Okay. On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. Chair of the committee.
Madam Speaker.
Chairman of the committee.
Madam Speaker, I have a technical amendment. It fixes a typo at the desk. The amendment number is 523021.
Amendment number 1.
Madam Speaker, it is in fact it's a technical amendment that corrects a citation within the bill. I'd move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment has been adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Great debate on both sides. And this ends the work at the desk this evening, 9:56. All committee bill hearings are listed on the Maryland General Assembly website, and a quorum call before adjournment.
Madam Speaker.
As everyone recorded their presence, the clerk will take the call. There being 135 members present, the House is still in session. Recognizing the Majority Leader.
Thank you, Madam Speaker. With great thanks to the clerks and troopers who have stayed late with us tonight, I move that the House stand adjourned until Thursday, March 11th at 10 a.m., Legislative Day, March 3rd.